Hi, good afternoon if you're in the east, and good morning if you're out west. You are listening to the department's new Title IX rule, a detailed examination, which is a webinar being put on by Thompson and Coburn LLP, law firm, based here in the United States, and is part of our higher education webinar series. I'm going to start out here with some housekeeping while folks are still joining, and we'll go here to our housekeeping slide. So the first thing I just want to note is that we do have a number of widgets down here at the bottom of the screen. If you have any questions during the webcast, we would ask that you submit them through the Q&A widget at the bottom, and we're going to try to answer those at the end. We have a lot of content to get through today. We're going to try to answer some questions we think are likely to come up just in the course of the webinar, but then at the end we will start curating and going through the questions that you've submitted there in the Q&A widget. A copy of today's slide deck is available in the resource widget, so you can go ahead and download that now. I will also highlight there's another document in the resource widget, which is a comparison document, and I'll talk about it again a little later on, but it is sitting there right now as well, and you are welcome to both of those. In fact, we would love for you to download them and take advantage of them. You can find answers to some common technical issues located in the Help widget at the bottom of the screen, and if you're having technical difficulties and you're able and you want to enter those into the chat or the Q&A, we are fortunate to have someone here online with technical expertise who may be able to help you solve those as well. Finally, as with all of our higher education webinars, this webinar is CLE accredited. In this case, it's already been approved in California and Illinois for 3 hours of general CLE credit, and in Missouri for 3.6. CLE credit is also pending in Texas. We award CLE based on attendance for in this case, the entire 180 minutes. So please remember that you have to be on and engaged. That having been said, if you have participated in our webinars in the past, you know, typically we have these little pop-ups that you have to click on to show that you are still there. You're not going to see that feature here, and you don't need to worry about it even if you're looking for CLE. So you will not see the pop-ups. That's because in 180 minutes we thought that's going to be a lot of pop-ups, and we don't want to annoy people, and we confirm that that will not impact your ability to get CLE. Finally, as always, we have a survey that we ask you to take at the end of the webinar, and we are very grateful for any feedback that you can take the time to provide. We do always read the surveys and try to take them into consideration so that each webinar is better than the one before. So I mentioned earlier, you're listening to a webinar that's being put on by Thompson Coburn LLP. This is a law firm. We're a pretty big one. We have getting on towards about 400 attorneys with offices around the United States. I am sitting in St. Louis. Typically, I'm in my office looking out over the arch, but I'm in the small town of Webster Groves today, beaming from my upstairs office, as is the case I expect for many of you. We also have offices in Chicago and LA and Dallas, DC, places like that, and you're always welcome to check out our website. My name is Aaron Lacey. I lead our higher education practice. We have a group of attorneys in the firm who are dedicated to working with institutions of higher education, either full-time or much of their time. And I'm also the host of this series, so if you listen in regularly, you have certainly heard my voice before. I'm fortunate that I have a number of people who are part of this practice and dedicate a better part of their time to working with colleges and universities, so the many folks who are dialed in today, and there are some of those beautiful people. I will also add that this is one I mentioned earlier in our series. So this is actually the last one for the 1920. We tend to track the academic school year in the sense that we start in August and go through May. And if you want to go back and listen to any of our prior webinars, they are online and available and free on demand, and you can do that. And these links are live links, which, by the way, brings me to another point. Throughout this presentation, anytime you see something that is in gold and underlined, that's a live link. And we've saved these links into the PDF of the slides, so when you download those and you bring them up later, you can follow all these links and go look at underlying resources. And I will also note that particularly for this presentation, we have worked hard to put a lot of content into the slides so that they can serve themselves as a resource. So you will see lots of places where there's information here, and there are citations and also links that may be of value. So who are you going to hear from today? We have three speakers. The first is me, Aaron Lacey. I mentioned earlier I'm the practice leader for the higher education practice, and I work with institutions full-time. So my entire career has been spent as a higher education attorney. I have spent some time in-house, but most of my time has been outside in private practice with law firms and education practices. And part of what I do is work with schools that are going through administrative proceedings or investigations with all forms at the department, so federal student aid and also the Office of Inspector General and Office for Civil Rights. And I've added here at the bottom, so I'm a Duke University and Vanderbilt guy. I don't know if anybody else is out there from great states of Tennessee or North Carolina. I'm joined today by Scott Goldschmidt, who is a counsel in our higher education practice. Scott is the former Deputy General Counsel for Catholic University and was there for about a decade, and really pleased that he's on today. He was there from 2011 until just a couple of months ago. So from the sort of first big wave of guidance that came out of the Obama administration concerning Title IX over the next decade, he was there in-house working through and implementing and dealing with many of the same challenges that the folks you all on the phone today have dealt with at your institutions when it comes to trying to understand and implement all of this Title IX guidance and these rules that are coming our way. Scott routinely assists folks with matters involving discrimination law, whether that be Title IX, discrimination based on sex or disability, and has a lot of experience, deep experience actually, dealing with student affairs, employee matters, and things along those lines. And he is a George Washington University man and a Catholic man, graduated from Catholic University Law School. And finally, we have Leslie Wines, who is our Director of Partner Recruiting and Integration. And you might say, and you might have wondered when you saw this, the announcement go out, why are they including someone who is not a practicing attorney at the law firm right now, but is actually in an administrative role? It's because Leslie, before joining our firm, spent over a decade with Northwestern University in various administrative capacities, and while she was there, also served as an adjudicator on their panelists and as a panelist and advisor in their hearing and appeal system, and adjudicated routinely matters involving allegations of sexual misconduct. So, you know, we thought we wanted to try to bring different perspectives to this, and I mentioned earlier I've spent most of my career in private practice working with schools. Scott has spent most of his career in-house in the general counsel office, and Leslie was an administrator and an adjudicator for many years dealing with Title IX matters. So we like the idea of sort of bringing different perspectives to this and hope that you all will benefit from that. She's a graduate of University of Michigan and Harvard Law School. Some of you may have heard of that, as it is more commonly known, the Duke of the North. Leslie, is that right? The Duke of the North, that's what you guys... That's my understanding, is that's what people commonly say when they refer to it. So here's our presentation overview. This may have just caused you to catch your breath. And I'm going to take this moment to sort of stop and say, look, if you have not already poured yourself a glass of wine, maybe now is the time to do it, or whatever your drink of choice may be. This is the first time we've ever done a 3-hour webinar or training session. In the past, we've had some where we've broken them up into series, but we felt like it was important once we got into this to stay in it, because it's, you know, it's related. It's all part of a single sort of concept, and we didn't want to break away from it. But we understand that we are going to be putting a lot of stuff out there today for you to try to absorb. And here's my advice. First of all, as I mentioned, the slides are packed, and they are packed with great information, and they're intended to be a resource. All of our webinars, including this one, are available free and on demand on our website. So this webinar today will be available probably within 24 to 48 hours, and you can go back and listen to it. You can go back and reference the slides. So my advice typically when I'm doing a training like this that's just got a lot of content and is fairly intensive is to suggest to folks, you know, sort of let it wash over you, pick up what you can, and know that you can go back and dig deeper at a later time if you want to do that. The other thing is, my gosh, we're doing 3 hours today, so if folks need to get up and take a break, by all means, you know, we understand that, and these resources will be available, including a recording of the webinar itself, and you can always come back to it. So understanding that we're about to throw a lot at you, keep in mind, you know, you can digest what you can now, and you can digest more later at your own pace. But it is important and it's going to be critical that institutions over time and sooner rather than later really start to get their minds around all of this. Also wanted to highlight a couple of resources. The first I'm calling our critical resources. So the Office of Civil Rights has already indicated it's got a blog up, and it's had this blog for a long time, though it has rarely been used, or I should say it's been used infrequently. But they have indicated on a go-forward basis that as they start to think about this rule and its practical implementation, and questions come in and they decide to sort of put out information, they're going to do it on this blog. And I don't know if you can see this image, but if you look closely, you'll see that this image is actually the first blog post, and it went up 2 days ago on May 18th, and it gets at what has to be on your website with regard to training materials and a couple, 3 other questions. By the way, anytime you see an image like this in one of our webinars that sort of looks like a web page, you can click on it. It's a live link, and it will take you to that blog. The other thing is the Office of Civil Rights has indicated that you can use this email address, open@ed.gov, to send them questions that you may have about this new Title IX rule. So these are both critical things that you'll want to be mindful of. If you're responsible on your campus for following and implementing Title IX, you're going to want to keep an eye out on that blog, and you may want to shoot some questions in periodically to the open@ed.gov webpage. The other resource I'll note, I mentioned earlier there's a second resource in addition to the slides in the resource widget. It is a comparison that we created. So what we did was we took the current regulation for all of Part 106. For those of you who are sort of lawyers and legal nerds, you'll know Part 106 is actually where all of the department's Title IX regulations are located. So that's 34 CFR, Code of Federal Regulations, 34 CFR, Part 106. That includes the new rule, but it's everything, right, that has been promulgated by the department and is intended to carry out the Title IX statute. So we took the whole part as it exists now, and then we looked at the Federal Register and what the department said they were changing. We created a second document that implemented those changes, and then we ran a comparison, and we've provided you with the comparison document. I personally, as an attorney, you can look at the Federal Register, but really it's just showing you the changes or what's new. I like to be able to see what the new law looks like in the context of the existing law from start to finish. I find that very helpful. So we did that for our purposes when we were reviewing the rule, and we wanted to share that with you, and I hope that you will find that a helpful resource. So let's talk about the Title IX timeline. I would consider this an advanced webinar, right? I mean, we're assuming most of the people dialing in know what Title IX is, but I do think it's helpful to have a little bit of context leading up to where we are right now. So Title IX, we're talking about Title IX, the Education Amendments in 1972. That's the statute that was promulgated or enacted by Congress, rather. And you'll note 3 years later, the department created Part 106, which I was just referring to, and that's, their regulations that implement Title IX. And then you'll see there's a jump. 22 years went by. Okay, 22 years went by. And for the first time, the department published a meaningful guidance document, not new regulations, but a meaningful guidance document on the management of sexual harassment at institutions, so both elementary, secondary, all the way up through higher ed. And after that document came out, there were individuals at various institutions who started to put lawsuits out there, the purpose of which was really to try to sue their institution, and the argument being that their institution wasn't complying with Title IX. So you had a couple of big cases that went to the Supreme Court in 98 and 99, Gebser and Davis. And we have some detail about those. I'm not going to go into it because Scott is going to talk about Gebser Davis in a few minutes. But I want to highlight here, you had the statute in 72, you had some regulations in 75. 22 years go by, you get a little guidance, right? And then you have these two big Supreme Court cases that are really about, when a person can sue a school for failing to comply with Title IX. Okay. Then we get a little more guidance, 2001, 2000, 2006, all right? But you have another decade that goes by, and the 2001 guidance the department put out, again, it dealt with sexual harassment, and it was largely put out to take into account those two big Supreme Court decisions from 98 and 99, right? And then you get the Obama era, Obama administration's Title IX guidance, right? That was 2011 and 2014. and then in May 2016, the guidance specific to transgender individuals and how institutions should relate to them on campus. So this, of course, the 2011 guidance followed by the Q&A in 2014 shook things up, right? I mean, for almost 30 years, very little had been done other than a little bit of guidance, and schools sort of had a sense as to, you know, how sexual misconduct should be managed. For the most part, up until 2011, when you said Title IX, most of us still thought of equity in athletics, frankly. And 2011 changed all that. So you had all of this guidance that came out 11, 14, and 16, right? Then we had an election. And in February of 17 and September of 17, the current administration essentially rescinded all of that guidance that was in the yellow box on the prior slide, right, from 11, 14, and 16. And of course, that's the problem with making policy through sub-regulatory guidance, executive orders, et cetera. And that's not a criticism, it's just a reality, right? I mean, if you do it that way, it's really easy to undo because it's not actually law and it didn't go through a rulemaking pursuant to the APA. So this administration came along, stripped that 2011, 14, and 16 guidance off the books and said, we're gonna start things over, but we're actually gonna make a new rule. And this will be the first regulation since 1975 that has any meaningful guidance and impact on the management of allegations of sexual harassment at colleges and universities, and is promulgated pursuant to Title IX. So November 18, we saw the proposed rule. As many of you know, there were 125,000+ comments that were filed during the notice and comment period. Takes a while to review that many, and then in May 2020, the department actually put out its final rule. And that's what we're talking about today. In fact, yesterday, if you didn't catch it, the final rule hit the Federal Register. So we have a link here to the official publication. The effective date of this final rule, the effective date is August 14th, 2020. So, you know, a couple of months from now, couple and change, schools are expected to be compliant with this rule. If you right now have looked at this rule a little bit, or even if you haven't, and that just strikes you as a very short runway, you're absolutely right. Of course it is. It's a very short time frame, and you know, ACE and NICU and all the other big associations are already pushing back on the department and have expressed in the press openly, you know, great frustration. I think schools, of course, are already dealing with the pandemic. You've got people working from home. The idea that you might have to totally overhaul significant policy elements at your institution and train people and get into compliance with this by August 14th. I'm not in house anymore, but it's still, just saying that out loud sort of makes me cringe. And I'm sure for those of you who may have some responsibility for implementing this on your campuses, it's not any easier. Your glass of wine may already be empty, and we're only 10, 20 minutes into the presentation. So pour another and take a deep breath, and we'll keep moving forward. Now, you may say, well, why, by the way, did the department, why did they do this? I mean, ACE and others said, please don't roll out this Title IX rule. Word on the street was it was ready and packaged several weeks ago and had already cleared the Office of Management Budget and could be published. And there were those who went to the department and said, please don't do it right now, right? I mean, we're in this unprecedented period of upheaval and disruption, and it would put an enormous burden on institutions to try to absorb and digest and implement this rule by August 14th. Well, okay. So there are several things that Congress could do to try to take aim at this rule, assuming that there are people in Congress who don't like it, and that's a pretty good assumption, right? Because in fact we know that there are many. So one thing is, you know, Congress could pass standalone legislation, by the way. Keep in mind, this is a regulation the department has promulgated pursuant to its authority and the direction from Congress to carry out Title IX. If Congress goes back and revises Title IX and changes it, you know, the department's going to have to potentially change its regulation. That's how it works. For those of you who deal a lot with laws and regulations, or maybe if there are any on the line who've dealt with federal student aid, we see that all the time, where the department will issue regulation, then Congress will reauthorize the Higher Education Act, and they'll change a bunch of stuff, and then the department has to go back and rewrite the regulation it just wrote. So you could have some standalone legislation where Congress could attempt to change this rule. The Congress could attempt to do it through HEA reauthorization. That's the reauthorization of the Higher Education Act. And in fact, the Democrats have been saying for the last 18 months that they did not want to go forward with HEA reauthorization unless Title IX reform was a big piece of it. Now, late last year, Senator Murray, who is the ranking Democrat there on the Senate Health, Education, Labor and Pension Committee, the HELP Committee, which oversees education matters, she and Bobby Scott on the other side in the House both suggested that maybe they would be willing to move forward even if Title IX reform wasn't part of HEA reauthorization. But the bigger point to all of this is, as long as you've got the current setup that we have, right, with the Democrats holding the House, Republicans in the Senate, and Republicans in the White House, you're probably not going to see standalone legislation or HEA reauthorization. But that brings us to the Congressional Review Act. And this is why I think the department, this is just Aaron Lacey speculation, but as an administrative law guy and an agency guy, this is why I think you saw this hit when it did. So keep in mind, the Congressional Review Act, which we heard a lot about when the last administration came in, allows Congress and the President, if a rule has come along that they don't like, and it's a fairly recent rule, it allows them to strip it out of the books. Right? And to do that, the rule has to have been reported to Congress within 60 legislative days, and there are some adjustments to that depending on if you have an administration change and a new Congress, but it essentially allows them that ability to strip the rule off the books. Okay, so if in November the Democrats take the Senate and the White House and then hold the House, right, then they would have the ability potentially to use the Congressional Review Act to kill this rule. And you say, well, gosh, this rule is, it's May right now. So in 2017, when the Trump administration came in, they were able to use the CRA to kill a rule that had been reported to Congress as far back as July 2016. So this administration, this Title IX rule has been a major initiative. And if you're the folks sitting in the White House right now, you know that every day you go past May and you don't report this rule to Congress, it becomes more and more likely that it will fit within that 60-day window. And if you lose the elections big in November, it creates an increased likelihood that a subsequent Congress could just strip this thing off the books. So it is my little opinion that a big consideration for why they decided to go ahead and put this rule out there, and I suspect they will report it to Congress sooner rather than later, is to try to insulate themselves from the CRA attack. By the way, if you want to know more about the CRA, the Congressional Review Service has done an excellent overview of it and how it works, and you can just click on the link and that'll take you to the overview. It was updated in January. You could also see regulatory and judicial activity. So if you do get a future administration and Congress, future Democrats in the White House, so after November, and let's say they don't use the CRA, you could still see the Department of Ed potentially through guidance, selective enforcement, unofficial delay. They could really impact this rule and the implementation of the rule. You could see the removal of this rule through subsequent rulemaking, right? So if you get Democrats in control of the U.S. Department of Education, they could just start a new rulemaking process, and they could ostensibly, as part of that, has to go through notice and comment, but they could still strip this whole thing off the books. I mean, we've seen in other areas, like with the bar defense rule, now 3 different versions of that rule. Every time we get a new administration in the White House, they decide to rewrite it. And of course, legal challenges, as I'm sure you know, there's already a lawsuit that's been filed against this new rule. I suspect that there will be many more, although the folks, we were listening into NACUO's webinar earlier this week, and I agree with them that, right now, while there's a lot of litigation out there, it's not sure that any of that will be successful or there will be an injunction. Certainly between now and August 14th, there's no clarity that this rule might be enjoined. So our advice is, as difficult as it's going to be to digest a lot of what you see today, that schools really do need to do their best to start moving towards compliance for that August 14th date. Finally, just keep in mind, you could also continue to see state legislative activity that could impact you depending on what state you're in and sort of your approach to the management of sexual misconduct on campus. It's highly likely you've seen a lot of blue states, meaning states with Democratic governors and executive branches, that have been promulgating or creating rules, if not statutes, governing the management of sexual misconduct on college campuses. New York is a great example of this. They have a very robust law, and in most cases, those laws sort of codify the Obama-era guidance from 2011 and 2014. And I think you're going to continue to see that, right? Particularly if there is not some other avenue that opens up to challenge this rule in the near future. So if you're in one of those states, not only are you contending with this Title IX rule, but as you're probably aware, you're also going to have to continue to try to square that with any state obligations that you may have. Okay, deep breath. So now let's get into the new rule. I'm a top-down learner. I like to have sort of the big picture and then start to get into more detail. So I wanted to start here at a higher level with this compliance framework. And I think this is going to be one of the most challenging things for schools and administrators to really wrap their brains around. And I encourage you to spend some time sort of thinking about this, particularly up front, because it's going to impact the approach you take with regard to your policies and revising your policy structure. And you have a lot of obligations, but you also have flexibility here. And I think for my money, and Scott and Leslie and I were talking about this yesterday, it is really worth, before you start rewriting policies, spending a significant amount of time with the folks in your institution who are responsible for thinking through these things and giving real thought to how you want to structure your policies. And I'm sure a lot of schools are going to approach it very differently depending on their particular needs, their size, their complexity. You will probably hear different advice from different attorneys and advisors and associations. The truth is you need to figure out what's right for you, so long as it's within these parameters. So when I say compliance framework, what I mean is the new rule has rewritten the Title IX regulations, right? And I mentioned earlier, if you look at our comparison document, it's not all just about sexual harassment. Now, this new rule is focused on sexual harassment and in particular the management of formal complaints of sexual harassment. But Title IX is bigger than that, right? Title IX prohibits discrimination based on sex, and that hasn't changed, and the regulations are still formed that way at the highest level. These regulations still obligate schools to adopt and publish grievance procedures that provide for the prompt and equitable resolution of student-employee complaints alleging any form of prohibited sex discrimination occurring against a person in the United States. Why do I stress this? So we're going to be focused for the majority of our conversation today on sexual harassment and the management of allegations of sexual harassment. But just keep in mind, at the highest level, if someone comes to you and says, I was discriminated against on the basis of sex in admissions, or in my employment, someone else got promoted over me, and I didn't get promoted because I was a man or a woman based on my sex, right? If someone alleges discrimination based on sex in any of those other areas outside of your programs and activities, right? Admissions, recruitment, employment, you still have an obligation under Title IX to have a process by which they can make that complaint, and you can work towards a prompt and equitable resolution of that complaint, right? So it's not just sexual harassment. It's all forms, right? Athletics, right? If you have somebody who says, hey, I'm on the women's volleyball team and we're not getting equal court time, right? You got to have a way to deal with that. And that's not sexual harassment, but it is discrimination based on sex, right? The only qualification here is that the department does say it still has to occur against a person in the United States. We're going to talk more about this qualification in a bit. But keep in mind, any form of prohibited sex discrimination, you've got to have a process to resolve those complaints. Okay, so that's the biggest bucket. Now, within that bucket, what about if you get complaints alleging sexual harassment? And we have a new definition of that. We'll get to that in a minute. But it's a subset of discrimination based on sex, right? Sexual harassment is a type of discrimination based on sex, and we've got a specific definition now that the department has given us. Why do I call this, and you'll look on this slide, it says Title IX sexual harassment? That's because I believe, and we've talked about this amongst ourselves, that one of the long-term impacts of this rule is going to be institutions are going to have to start dividing in their minds or distinguishing between sexual harassment writ large and Title IX sexual harassment, which is sexual harassment that specifically fits in the bucket that the department has created with its definition of this term. right? Formally, a lot of institutions, and when we worked with clients, it was the same way. We said, look, you have a sexual harassment policy or a sexual misconduct policy, and it needs to comply with Title IX and state law, but we didn't draw some sort of distinction. But now, as you're going to see as we get into this, you know, the department is saying, well, if it's a Title IX sexual harassment matter, it has to be managed a certain way. And if it doesn't qualify, you may even have to dismiss it under your Title IX sexual harassment procedures. But you may still have alternative procedures to manage non-Title IX sexual harassment, right? And those could be identical. Those could be slightly different depending on your needs. But I think a lot of the, again, outcome of this rule is going to be schools are going to have to start thinking that way. You know, you've got your Title IX sexual harassment and your Title IX process for managing Title IX sexual harassment. And then you've got your other process for managing sexual harassment that may not fall within the scope of Title IX, right? So Title IX sexual harassment, with or without a formal complaint, you have as an institution, if you have actual knowledge of this Title IX sexual harassment occurring, you have certain obligations. So remember, you have obligations if you've got any kind of discrimination based on sex. And now under the new rule, you've got obligations if you have actual knowledge of Title IX sexual harassment in an education program or activity of the institution against a person in the United States. Okay, so you've got stuff you've got to do if you learn of any kind of discrimination based on sex. You've got stuff you've got to do under this rule if you have actual knowledge of Title IX sexual harassment. Okay? And finally, you've got stuff you've got to do if you get a formal complaint of Title IX sexual harassment. Right? So in response to a formal complaint, you have to have a process now that complies with 34 CFR 106.45. And if you haven't seen that yet and you're a Title IX person, it will soon be burned into your brain, because 106.45 is the section of the regulation that dictates all the things you have to do with regard to your formal complaint process. So it's just important as we move forward and we talk about all of this stuff, when you look at that comparison document that we provided in the resources tab, right, and you start thinking about your Title IX framework and the policy framework that you want to develop, it's really important to keep in mind that you have different obligations depending on the nature of the discrimination based on sex, right? And you want to be very aware of those distinctions, because that needs to inform the development of your policy framework as you move forward. All right, so we've got some new definitions. There are in the new rule, there are actually 7 new sort of critical definitions. There are a couple of 3 others, but these are the really big ones. I'm going to talk about 4 of them right now, and you are finally going to hear from Scott and Leslie here shortly. The latter 3, the actual knowledge, supportive measures, and formal complaint, we'll address in the context of the conversation later on when they sort of come up. But we wanted to go ahead and hit these 4 right off the bat. By the way, I'll just point out in the lower right-hand corner on these slides, we include citations for you to the new rule effective as of August 14, 2020. And we actually went through there a few places where we have quotes from the Federal Register, and we were able to get those citations in yesterday as well. Okay, so this is the big key definition. Remember, I referenced a few minutes ago what I call Title IX sexual harassment. So in the new regulations, they have defined this concept of sexual harassment. And this definition may be different from what you have in your policy right now. It may be different from what your state law requires. It may be different from Title VII. In fact, we know it is, right? What's required under Title VII. But this is when we talk about Title IX sexual harassment, this definition is now in the law. And this is what you got to focus on when you're deciding whether or not a form of sexual harassment of which you have actual knowledge is actually covered under your Title IX procedures and processes and triggers your Title IX obligations. Okay, sexual harassment means conduct on the basis of sex that satisfies one or more of the following. We've got 3 buckets. Unwelcome conduct determined by a reasonable person be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. So in the old days, we would have referred to this as sort of your hostile environment standard. Second, all right, sexual harassment means conduct on the basis of sex, all right? And we're talking about in the case where an employee of the school has conditioned or conditions the provision of an aid, benefit, or service of the school on an individual's participation in unwelcome sexual conduct. So this is quid pro quo sexual harassment. Or finally, sexual assault dating violence, domestic violence, or stalking, as those terms are defined in VAWA, Violence Against Women Act, or the Clary Act. And so those of you who do Title IX work are surely familiar with VAWA and the Clary Act and sort of the creation of those terms and their bringing into the regulatory framework several years ago. So I'm going to stop here and turn it over to Mr. Goldschmidt.
Thanks, Aaron. I appreciate it and happy to give you a little break. It's a pleasure to be with everyone. So just jumping right into it, we thought it'd be important to kind of lay out the department's perspective in deciding to adopt the Gebser-Davis framework. These are two very important cases, and Aaron mentioned them in his timeline, and understanding where Ed's coming from with these cases is important to understanding the overall nature of the rule. So Gebser and Davis, for the purposes of federal lawsuits, established that proof of actual notice and deliberate indifference are required for a plaintiff to prevail for damages based on sexual harassment. So if you're filing a federal lawsuit based on Title IX, Gebser and Davis are the standards that you apply. The Department of Education, however, through their Office of Civil Rights, is in charge of enforcing Title IX compliance for administrative and regulatory purposes. So the Supreme Court has made clear that through this power, the Department of Education can, and has previously, imposed a higher standard of compliance in its enforcement of Title IX. So this means that purposes of the same violation or the same alleged violation that occurred to school, the Department of Education could find it was violation of Title IX, and a federal court using Gebser and Davis could find differently. So this was previous to the enactment of this rule. Ed is saying that this doesn't make sense. It doesn't make sense to have two different standards. It doesn't make sense for OCR and a federal court to come to two different conclusions regarding the same facts. So Ed's main push, and as they stated throughout the preamble, is to adopt the majority of this Gebser-Davis framework. So that means using actual notice, using deliberate indifference standards, and we'll describe these later, in order to be the main guts of the rule. But because Ed has discretion to enforce the rule as it sees fit in a higher way, it's using its discretion to add a little bit to this standard. Next slide, please, Aaron. So I think Bear's explaining what I'll be doing, and my role here, Aaron's role is to kind of go through the rule and explain kind of what the regulations actually say. But along with the regulations, the Department of Ed was kind enough to give us what's called the preamble. So of the 2,033 pages in the unofficial federal rule, about 2,000 of them was this preamble. The actual rule was about 33 pages. The rest was this preamble, which is meant to inform the reader, presumably who's not an expert in the subject area, on the basis and purpose for the rule or proposal. So the fact that the preamble is so much longer than the actual rule, it makes sense that there's additional information, additional guidance that it provides in the preamble that helps us understand the rule. Some terms are defined a little better in the preamble, or their intent is provided, so we have a better understanding of where we're going. So it's not possible to cover all 2,000 pages, but what I tried to do in these additional questions is try and pick out some pieces of the preamble that I thought would be helpful to understanding, and pose a question and then kind of answer it myself. So Aaron mentioned that sexual harassment means conduct on the basis of sex. The statute doesn't just define the term, but the preamble alludes to it and explains that where conduct is sexual in nature, or where conduct references one sex or another, that suffices to constitute conduct on the basis of sex. And the department also notes that probing the subjective motives of the respondent is not required for the on the basis of sex determination. So the second thing to keep in mind is, does quid pro quo harassment, second prong of the sexual harassment definition Aaron mentioned, or the clear VAWA offenses, the third prong, need to be severe, pervasive, and objectively offensive? And the department makes clear the answer is a resounding no. So only the first prong, the unwelcome conduct prong of the sexual harassment definition, must be severe, pervasive, and objectively offensive. The department assumes that a victim of quid pro quo harassment or sexual harassment a victim of quid pro quo sexual harassment or a victim of a VAWA clery sex offense has been effectively denied access to education based on one instance. Next slide, please.
Very good. And I'll jump back in here. By the way, Scott and I, when we were preparing for this, drew straws to see who would read the 34 pages of regulations and who would read the 2,000-page preamble. And you can probably guess who drew the short straw. So complainant, respondent, and consent were the other three definitions we wanted to hit on now. Complainant and respondent, I think, are terms that, as defined, are probably what you would expect. The complainant means an individual who's alleged to be the victim of the conduct that could constitute sexual harassment. So your complainant could be your reporter, right, the person who comes and actually reports it to the institution or the Title IX coordinator, but it doesn't have to be, right? Someone else could report, and the complainant, in this case, the key concept is the complainant is alleged to be the victim. Your respondent is the individual who's been reported to be the perpetrator of the conduct. So that's the person on the other side of the issue. Consent. So the assistant secretary in this case, and you guys know, and I think Leslie, you're going to talk about this a little bit too, but consent can be a very critical and important issue in many of these proceedings. And what's fascinating is the department essentially has punted here. It simply says in the definition, the assistant secretary will not require schools to adopt a particular definition of consent with respect to sexual assault as referenced in this section. Now you see there's a little gold asterisk here at the end of that sentence. That is my cue to turn it back over to Scott and Leslie. So Scott and Leslie, I'll leave it to you guys. Talk a little more about this concept of consent.
So thanks, Aaron. I'll start. And I think I'll start by addressing some concepts from the preamble. And so the definitions here, I think, as Aaron said, are fairly straightforward. But anyone who's been involved in Title IX and specific facts of cases, the permutations, the crazy situations are just limitless. So when I read these parts of the preamble, I thought it was helpful that the department kind of addressed some of these issues. So just really quickly to go through them. So the complainant definition is fairly straightforward, and any person needs to be treated as a complainant that's been alleged to be a victim of sexual harassment, irrespective of whether the individual has filed a formal complaint. But if the complainant wishes to file a formal complaint, the complainant must be participating in or attempting to participate in the school's educational program or activity at the time of filing the formal complaint. So anyone can be a complainant, but kind of gets a little more restrictive if the complainant wishes to file a formal complaint. So that begs another question, a related question that the preamble addresses. Can a complainant who's graduated or a complainant on a leave of absence, or that's a prospective enrollee, file a formal complaint? And the department's explanation is, well, it depends. So a complainant who's graduated may still be, quote, attempting to participate in an institution's education program or activity. So the preamble gives an example of a graduate attempting to participate in a program when they've graduated but intend to apply to a different program, or when the graduated complainant intends to remain involved in the recipient's alumni programs or activities. In that situation, a graduate may still potentially be attempting to participate in the program and could file a formal complaint. So similarly, a complainant on a leave of absence may be participating or attempting to participate in an educational program or activity. And the example given is when the complainant is still enrolled as a student, even on a leave of absence, or may intend to reapply after the leave of absence. And last, the department clarifies that a complainant who's left school because of sexual harassment, but expresses a desire to re-enroll if the institution responds to the sexual harassment, would be attempting to participate in the institution's education program or activity. For respondent, the preamble clarifies that any individual can be a respondent, whether such individual is a student, faculty member, another employee of the recipient, or a person without affiliation. And the nature of their affiliation has implications later, but for the purpose of the definition, anyone can be a respondent. And regarding consent, as Aaron pointed out, the department leaves the crafting of the definition of consent to schools, But the preamble explicitly states that the school is responsible for clearly defining consent and applying that definition consistently. So relatedly, the preamble addresses whether the regulations need to contain or a definition about the absence or negation of consent. And the department punts here. They decline to impose a particular definition of consent or terms used to describe the absence or negation of consent, such as coercion or incapacity. So Ed explains the preamble and regulations don't address whether things such as intoxication negates consent, whether verbal pressure amounts to coercion negating consent, or whether affirmative consent standards do or do not represent a best practice. So that would be left up to the institution. It also notes that many schools are under state law requirements to apply particular definitions of consent. And if that's the case, the institution obviously needs to follow those laws. But in the absence of state laws dictating otherwise, schools can define consent and define terms commonly used to describe the absence or negation of consent. And with that piece of the preamble, I have a question for Leslie. So Leslie, many schools will soon be considering whether to keep or craft new definitions of consent, and possibly, as we discussed, the absence or negation of consent. So as a former adjudicator, do you think schools should be looking to their adjudicators for help with the definitions based on their experience? And on a high level, what are some things you would want to see as an adjudicator defining and applying a definition of consent?
Thanks, Scott, for the floor. And, as both you and Aaron have already stated in this presentation, it's interesting that the regulations don't define consent uniformly across schools, given what an important part of the analysis consent becomes. And actually, as an adjudicator, it's one of the most complicated aspects of deciding a case in many instances. I think to answer your question most simply, when drafting new rules, getting the perspective of those who have to apply the rules, i.e. the adjudicators or those who serve as advisors in the process, it's always helpful, right? I think the challenge here is going to be the relatively quick turnaround time for implementation, especially given how busy the professionals who are going to be working in this arena within educational institutions are already managing a number of mission-critical decisions during the pandemic. So I think you're just going to end up with a resource constraint, time constraint challenge. But the more you can understand and take the time to understand how the adjudicators and advisors need, what do they need to know in order to make effective decisions and comply with the new process requirements, the better you're going to do in drafting language that is ultimately implementable. Specifically, as we said, consent can be really challenging in sexual misconduct cases, especially for students. In my experience, many of the cases I adjudicated involving students also involve the use of alcohol or drugs. And also, in today's time, these cases are complicated by the sort of heavy social pressure or the culture around sexual exploration and identity. And I think this becomes especially complicated and true when one or more of the parties in a case present in a blackout or a brownout state or is unable to recall all of the details of the interaction. And so it's incredibly important that schools think about all of the aspects and elements of consent when drafting their policies. For example, how is consent expressed? Does it have to be present or ongoing throughout the entire sexual engagement? Can consent for one act be considered consent for a subsequent act? Or must consent be present for each and every disparate act? Schools also have to, as you've both already described, define capacity to consent. How does the use of alcohol, drugs, unconsciousness, or sleep factor into the evaluation of consent? And where is the line between tipsy and incapacitated? Can consent be given during a blackout or a brownout? Depending on who you impanel to serve as your adjudicators, these are not easy questions to answer for most people operating within an institution's framework. And so ensuring that all community members understand how consent is formed and communicated is key. You didn't ask that, but I'm going to take us sideways a little bit into training for all community members, because I think once you do define what consent means and what capacity means, it's the communication of those definitions that's going to be really important going forward. I believe that training for students, faculty, and staff should be a regular part of the school's onboarding and continuing education while a member of the community. One of my favorite aspects of Northwestern University's training is the cartoon video about consent as analogous to making a cup of tea. If our participants in today's session haven't seen that video before, it's easily accessible on YouTube. And I love it because of its simplicity and its impact. A key to community compliance with behavioral expectations is figuring out ways to train people that are memorable and impactful and likely not to get lost in loads and loads of other onboarding content. We're going to talk a little bit later about training for advisors and adjudicators who take part in the process, but consent and capacity certainly deserve significant attention for both roles.
Thanks, guys. And by the way, I should mention, and I meant to note this at the outset, you know, Leslie obviously was mentioned was with Northwestern in years past. Scott was with Catholic, but just to be very clear, I mean, Scott is not speaking for Catholic University. Leslie's not speaking for Northwestern. Those institutions have their own and are about their own business. And I just wanted to make that clear. We don't speak for any institution here today. And again, I should have mentioned that earlier. Okay, so the next section, we're talking about responding to sexual harassment. If you think back to the graphic I showed earlier, I mentioned that, you know, you have certain obligations if you have an incident of discrimination based on sex, whether it's sexual harassment or not, right? Any kind of discrimination based on sex. And then you remember the second box, you have certain obligations if you have actual knowledge of Title IX sexual harassment, but we're still short of a formal complaint. So we're just talking about the moment at which you have actual knowledge of that Title IX sexual harassment without regard to whether a formal complaint has actually been reported. So that's where we are right now. We're in that sort of second tier. Okay. So per the new rule, an institution must respond to Title IX sexual harassment. And going forward, I'm not going to keep saying Title IX every time, but when we're talking about sexual harassment, we mean sexual harassment that satisfies that definition you saw earlier. So an institution must respond to sexual harassment when the school has actual knowledge of the alleged sexual harassment, the alleged sexual harassment occurred in an education program activity of the school, and, so it's and, these are conjunctive, and the alleged sexual harassment was against a person located in the United States. So you are under Title IX, you are obligated to respond to Title IX sexual harassment when these three things are true. Actual knowledge. So the department actually provides a definition of actual knowledge. They say actual knowledge means notice of sexual harassment or allegations of sexual harassment to a school's Title IX coordinator or any official of the school who has authority to institute corrective measures. Now, Scott's going to talk about this a little bit more, but clearly this means that understanding who within your organization is a, quote, official of the school who has authority to institute corrective measures has now become a really important concept, right? Because it informs actual knowledge. It's your Title IX coordinator plus any of those individuals, right? Or to any employee of an elementary and secondary school. We've included that, but our focus today, as you know, is primarily higher education. Keep in mind the mere ability or obligation to report sexual harassment or to inform a student about how to report sexual harassment or having been trained to do so does not qualify an individual as one who has authority to institute corrective measures on behalf of the institution. And that's in the regulation. That's not the commentary. This is actually written into the law. So the department is, in the regulation itself, creating a little bit of a box around what they mean as to what's included and excluded from that notion of official of the school who has authority. Okay. Scott, why don't you give us a little more on this topic?
Sure. So some quick color commentary from the preamble. So hopefully this was clear, but just to button up, who can make a report? Any person can make a report. The thing that we want to emphasize here, report's different from a formal complaint. And a formal complaint is not required for actual knowledge. The report done by anyone is required, and that can be done by any person. So second question, who's an official with authority, as Aaron mentioned, to institute corrective measures on behalf of the institution? So remember, the definition we just went over explained that actual knowledge means notice or allegations of sexual harassment to the Title IX coordinator or any official with authority to institute corrective measures on behalf of the recipient. So there's no such thing as constructive notice anymore. So determining which employees may be officials with authority is fact specific. The preamble explains, however, employees generally know a supervisor, but not a coworker, has authority to institute corrective measures, and the student likely understands that deans generally have authority to institute corrective measures. So the preamble is kind of hinting that at least supervisors and deans would be considered officials with authority, but an institution would need to make a fact-specific determination about what that list would be. The preamble explains that schools can choose to identify such officials with authority by providing a list, and we think that'd be a good idea that the institutions should strongly consider. And last, which employees must report sexual harassment to the Title IX coordinator? So again, the department gives wide discretion for institutions to craft and implement their own employee reporting policy to decide which employees must report harassment to the Title IX coordinator, to decide which employees may listen to a student or employee's disclosure without being required to report it, and which employees must report sexual harassment to the Title IX coordinator, but only with the complainant's consent. So here, if your institution is comfortable with the current responsible employee framework, you have the flexibility to keep it. The change here is that an employee that must report to the Title IX coordinator by policy is not necessarily an official with authority. And notice to officials with authority is the key that's necessary for actual knowledge.
Thanks, Scott. And I'll just reiterate here, because I've seen a fair amount of press that is conflating these notions of who has to report and this concept of an official with authority and what constitutes actual knowledge. And again, just to reiterate what Scott said, you as an institution can set your policy regarding who has to report sexual harassment, of which they learn or see or et cetera, to the Title IX coordinator or whoever else on your campus. But you as an institution can set that policy, and you can still require that all or a significant percentage of your employees have to report, including, I saw a headline that said, athletic staff no longer have to report sexual harassment. Well, they do if your institution requires it. Surely they do, right? But that is up to your institution to determine. The key concept here of authority, an official with authority to institute corrective measures, doesn't get at who has to report. It gets at the point at which you have actual knowledge. And it is the point at which you have actual knowledge that your obligation to respond is triggered, right? So that they're different concepts and they serve different roles. You can still require many of your employees to report sexual harassment to the Title IX coordinator. And then the question is, at what point, when your Title IX coordinator or this other group of officials learn, who's going to be in that group for purposes of triggering the obligation to respond. Also, keep in mind, and we said this earlier, and we'll say it again, I suspect more than once through the remainder of the presentation, but you also can have a policy that requires, obligates you to respond to non-Title IX sexual harassment. So even if there is sexual harassment that is reported to someone other than an official with authority to institute corrective measures, let's say it's not Title IX sexual harassment, you could still respond under your policy, and the institution could still obligate itself to respond, right? But it wouldn't be a Title IX obligation, right? And it might not be Title IX sexual harassment. And this is why I said at the outset, I think schools are going to start having to conceptualize within their policy frameworks, what's a Title IX complaint, what's a Title IX form of sexual harassment, and what's our Title IX process, because I suspect many institutions are going to end up with policies that capture and are used for managing sexual harassment that falls outside of that, or sexual harassment that may have been reported to someone who's not an official with authority, right? Okay. Moving on. So what about, we said there are three elements, right? The first is when you have actual knowledge. The second is it has to be in a program or activity. And the third, that it has to be occur against a person in the United States. So with regard to that second prong, program or activity, the department offers up this definition that's to be used in the context of Title IX sexual harassment. an education program or activity of the school includes locations, events, or circumstances over which the school exercised substantial control over both the respondent and the context in which the sexual harassment occurs, and also includes any building owned or controlled by a student organization that is officially recognized by a post-secondary institution. Now, those of you particularly who have complex campus organizations and may have off-campus housing or may own or operate or have relationships with rental properties, et cetera, probably looking at this going, I've already got potentially some places where I'm going to be unclear as to whether or not I exercise substantial control, and I would fall within this definition. So for that reason, I'm going to pitch it back to Scott to talk about some of the nuances.
Sure. Thanks, Aaron. So how does an institution determine program or activity besides the kind of cursory definition that Aaron went over? So the preamble gives a little bit more context. So they say unhelpfully it's a fact-specific inquiry, which we know. But the harder questions are things that occur off campus or not kind of within the four square walls or kind of traditional campus environment. So for off campus, it's important to note that it doesn't automatically mean the incident occurred outside of the recipient's educational program or activity. So the preamble explains that factors to consider in this context are whether the recipient funded, promoted, or sponsored the event or circumstance where the alleged harassment occurred. So if you do get something that's not entirely clear, it's off campus, you're obligated to do this fact-specific inquiry and kind of weigh the definition and the guidance in the preamble to determine if it's a program or activity that would put you under the Title IX umbrella. And second, if a student, this is a hypothetical the preamble gives, which I thought was helpful context. If a student sexually assaulted outside of an education program or activity, so for example, abroad, but subsequently suffers a Title IX sexual harassment event in an educational program or activity, what happens? So here, the final regulations and processes would apply only to the act of sexual harassment in the institution's program or activity. But the department makes clear, and as Aaron alluded to, the institution may choose to address the prior assault through its own processes or code of conduct, and likely they should. So as long as the act or the event or the facts are not covered by these regulations, schools have discretion to set up a process that works for them, and that could include things that are prohibited by these regulations, such as single investigator model. But the department also makes clear that an institution absolutely can apply the same process, the same grievance procedures under these regulations to cover conduct not covered. So this is a significant decision for schools, and I think one that should be kind of in that initial cut of things to consider, carefully weighing the pros and cons to each approach. So Leslie, let me ask you to start, because along with being an adjudicator, you also have the perspective of a school administrator. Do you have any thoughts, high-level thoughts of kind of how schools, what they should consider based on your experience?
Yeah, I have a couple of thoughts, and maybe we'll go a little bit back and forth here, Scott, because I think the first thing I want to address is, your statement that should there be, same processes or different processes. If it's technically non-Title IX sexual harassment, can you include in your process a single investigator model, for example, which is prohibited by the new rules? I'm going to say that there's an argument for treating all acts of sexual misconduct, regardless of whether they meet the requirements or definition of Title IX or not. The argument for treating them all the same is relatively simple, especially coming from a sort of student affairs or student experience background. If you think about community values being community values, right? Members should abide by those values, whether they are participating in activities on campus or off campus, engaged in a school activity or not. And so the argument for having a single or consistent process, regardless of whether it's Title IX harassment or non-Title IX harassment, is that all members of a school community should be treated the same, whether that conduct occurs in a building or a location where the campus or the school has some control, like a dorm or a fraternity house, or in a private setting, like an apartment building off campus. I also want to be clear that I think it's one thing to treat the adjudication of conduct that is not sexual harassment in nature, so theft or alcohol abuse, differently from sexual misconduct. But I think for some institutions, they'll grapple with the idea of treating acts of sexual misconduct differently based on where or when they occur. And if you're in that camp of struggling with that conceptually, it might make sense to maintain a single process, regardless of whether it meets the definition of Title IX. From the perspective of being an adjudicator or an advisor, I think there's also complications to having separate processes when it comes to impaneling or empowering individuals within your institution to serve in those roles as advisors and adjudicators. I would argue it's hard enough to train individuals who are not student affairs professionals or student conduct professionals to understand and implement rules for one process. And if you happen to have multiple processes that require participation from these adjudicators or advisors, how do you train them on the subtle differences or sophisticated differences between your processes? And if you are going to impanel or empower members of your community to participate as such, do you have a large enough population of people to train them on different processes or keep them separate based on the process for which they've been trained? I think, though, Scott, there are also important considerations for why processes could or should be different. So I'm going to throw it back to you to think about or talk about what schools should consider in that regard, and then maybe we'll come back to this idea of, what a school should take into account, having thought about the perspective I just shared and what you share in response.
Yeah, I'm sure happy to, and a little devil's advocate, and I think I'll take the perspective of the risk-averse outside counsel here, but the processes laid out under these regulations are really complex and highly detailed.
Yes.
And if an institution decides to adopt them by policy, likely they're creating a contract with the student that would obligate them, and there could be kind of liability if they don't follow this process. So I think an argument for having separate processes, or just kind of having a box around Title IX offenses and non-Title IX offenses, is just that schools can kind of go back to what works for them if they have something in the code of conduct, or develop something that's a little more simple, easier to administer, and kind of consistently enforced. Another important piece of the separate models, and maybe there's a kind of hybrid piece that we could discuss here too, is the fact that Title IX applies to employees as well, and we'll talk about that. Mm-hmm. This is a huge change for employees and HR and everything like that they'll have to go through these processes. So to the extent that employees could kind of have separate models, at least, that might be something. I think that's something that an institution should at least be considering.
And this is Aaron. I'll just add. Let me just add to Scott's comment. I mean, I think the other thing that's worth noting is institutions may actually feel like their existing processes are superior to what's being required under Title IX. So not only might they be easier to administer, but you might actually say, we believe in a process that avoids direct cross-examination, which we're going to talk about later. We think that the right way to do this, frankly, is to have folks pose questions to each other in writing. So if we have a non-Title IX complaint, while it is more complicated and you have different processes and there can be inequity there, on the other hand, we actually believe not only is it easier to administer, et cetera, but we actually think this alternative process ultimately is the better process. And it's unfortunate that we can't use it because we have to use what Title IX gives us. But when we're outside of Title IX, we're going to use the process we think is the best process for everybody involved.
Yeah, Aaron, I think that's a really good point, and especially sort of thinking about the way in which I participated in a process versus the way in which a process will look under these new rules. I can certainly appreciate having some feelings like old processes may be better or superior than what's being directed, and I think schools are going to really have to grapple with that. I think it's a really difficult decision to decide, how do you pick the superior process when you can, but subject others to what you believe is an inferior process. How do you manage that, the equity of that, and the application of that? I think those are really difficult choices, and I don't I don't have the answer to that, certainly. But I also wanted to talk a little bit, Scott, you asked me, based on my perspective as an administrator of a school, sort of what goes into thinking about separate versus uniform processes. And I'll answer that from my perspective as a former assistant dean at a professional school within a large decentralized university. We routinely grappled with, what conduct matters can we handle within our professional school student affairs office versus what matters do we send to the university for a resolution under, central university procedures. And we uniformly decided time and time again that all sexual misconduct matters warranted adjudication at the central university level so that the processes were consistent across schools and adjudicators were well trained and supervised by the Office of Student Conduct and the Office of Equity. And personally, I think that was a pretty good call for us. It may not be the right call for every school, but it was a good call for us. And I would advise schools who are thinking about whether to sort of manage these matters in-house or, for example, to manage non-Title IX sexual harassment, quote unquote, in-house and centralized Title IX sexual harassment processes at a university, to think about a couple of things. One, I would really ensure that whoever is responsible for putting together processes at the school level understands the legal rules and compliance requirements, and whether it means that the person who is drafting and implementing those processes is a lawyer, him or herself, or has sort of direct line into in-house or outside general counsel for the university. You really need a lawyer to guide you on the creation and implementation of process. And so if you are a student affairs professional who doesn't have access to that resource, really think about whether or not you're in a position to be able to, in an ongoing and compliant way, be in line with the rules that are coming down for Title IX or any other codes of conduct that continue to evolve. I'd also think about, if deciding to adopt your own processes, who is going to be the adjudicator? Who, if you decide to have advisors in your process, who will serve as advisors? Do you have the population of people you could place into these roles? Do you enlist volunteers? That's how Northwestern handled panel members. We were, for the most part, professionals outside the Office of Student Conduct who were volunteering for that role in addition to our full-time jobs. Or do you create a role that has formal responsibility for managing whatever conduct process you put in place for your school? I think you have to think about how important is consistency in process, and that's sort of where I started this whole thing. Do you treat one act of sexual misconduct differently from an identical act of sexual misconduct just simply because of where the conduct occurred? Do you treat employees separately from students? Do you treat graduate students separately or differently from undergraduate students? Degree-seeking students differently from non-degree-seeking students? So I think there are a lot of decisions to be made around the relevance or importance of consistency in process across different populations, both on the student and across the community perspective. And then the last thing I would encourage schools to think about, especially if they're thinking about bringing some conduct processes in-house within a student affairs unit, is to really think about the challenges that arise from failure or challenge to separate an office that provides students with a place of comfort and advocacy and an office that disciplines students or controls their conduct. Sometimes when schools centralize both functions into the same office where they have the same set of administrators responsible for advocating on behalf of and supporting students, also making decisions about responsibility for violations of code of conduct, that can lead to some conflicts of interest and tensions or discomfort for the students, not knowing whether they're going to be interacting with that professional as an advocate or interacting with that professional as a disciplinarian or both. And so that's something I think really important for schools to think about, is if you are writing your own processes, if you are administering your own processes, from what office or group of people are you doing that? And do you have to think about the need to separate student advocacy and support from student discipline and conduct?
All great points. Great points. You know, and it's interesting, Leslie, as I hear you talking too. I mean, one of the things I'm thoughtful about is, you know, your experience and Scott as well. You all were both at very large, complex institutions, and you know, of course,
Yep.
large institutions with significant employee and student populations have resources, but they have the challenge of volume. Right? I mean, if you've got 100,000 students, I always pick on Ohio State because they're so big, but you know, if you have 100,000 employees and students, you're going to have a steady flow of sexual harassment claims. It's just you put that many people in a place together. It's not about Ohio State. It's just you got a lot of people. It's like a city. You know, on the other hand, you have the Miss Betty's Beauty Academies out there that participate in Title IV and may have 15 employees. And, you know, they lack resources and experience. Unlikely they have in-house counsel. You know, these smaller career schools and technical schools, I'm sure they are looking at this thinking, how are we going to implement this? Where are we going to find the resources? It's rare that we get these complaints, but when we do, you know, the obligations are significant. And I suspect even the folks in the middle who may have a little more in the way of resources, but not a lot of money to spare, particularly right now, and maybe even be looking at uncertain futures. You know, I'm sure everyone, regardless of where you fit in higher education, it's going to be difficult figuring out how to implement a lot of this and comply with it, precisely because, to your point and Scott's point of how you guys are so artfully illustrating, it's complicated. And there are a lot of choices that have to be made. And schools are going to have to dedicate a fair amount of time to figuring it all out. And I unfortunately don't, at least at present, see any way around that. Not if you want to do it well. Not if you want to do it well. All right, with that being said, let's keep moving. So the physical location is the last criterion. In this case, the complainant has to be a person located in the United States. And this was an issue the department raised in the proposed rule, and they address here again. And they acknowledge that individuals experiencing sexual harassment outside of the country would not be covered. As Scott, you mentioned previously, that does not necessarily mean that the school, in fact, it clearly does not mean that the school could not still provide those folks resources and a process for resolving sexual misconduct that is even identical to their Title IX process. But it would not be a Title IX sexual harassment because it's excluded from this definition. I see an asterisk. I hope I didn't steal your thunder. Is that in the ballpark?
Nope. Just very briefly, just because we've seen, again, a couple reports on this and confusion, just wanted to, then the preamble clarifies that the jurisdictional limitation here does not mean only U.S. citizens are protected. International and foreign students studying in the U.S. are entitled to the same protections as Title IX as other individuals. So just wanted to make a very quick point.
Yeah, that's a really good point, actually. It is about physical location and not where, you know, whether you're a citizen of the U.S. or not. Okay, so let's talk about elements of a sufficient response. You know, what we were talking about a minute ago here is if you have Title IX sexual harassment and you satisfy that definition, then you have actual knowledge, right? It's in a program or activity, it occurs against somebody in the United States, then you have this obligation to respond. We're still short of a formal complaint. But we're still in that second box if you think back to those nested boxes. But you now have an obligation to respond. What do you have to do for that response to be sufficient? And again, I read earlier today someone had a quote in one of the articles I was reading, and I thought it was a good point, and I just want to emphasize it. Remember, Title IX sets the floor, not the ceiling. So you have to do at least this much under Title IX if you have Title IX, actual knowledge of Title IX sexual harassment. You can always do more. And that's a really important point. Nothing is prohibiting schools from adding on or going further or expanding these policies, and you may even be required to do so under state law. But at a minimum, you've got this floor now. You have to do at least what we're going to go over now if you want to be considered to have a sufficient response. So institutions must respond promptly and in a manner that is not deliberately indifferent. And remember, that ties to the standard set by the Supreme Court in Gebser and Davis. A school is deliberately indifferent, quote, only if its response to sexual harassment is clearly unreasonable in light of the known circumstances. Now, in the proposed rule, the department offered actually several examples, safe harbors, however you want to think of it, of conduct that would or would not constitute deliberate indifference. So they actually said, if you do this, it's deliberate indifference. If you do this, it's clearly not, and you would be considered to satisfy this standard. The final rule does not include these examples. It pulled that out. A school's response must treat complainants and respondents equitably by offering support measures to a complainant and by following a complaint grievance process before the imposition of any disciplinary sanctions against the respondent. So this is in the regulation itself when it's sort of talking about what's necessary to satisfy that deliberately indifferent standard. The Title IX coordinator must promptly contact the complainant to discuss the availability of supportive measures, consider the complainant's wishes with respect to supportive measures, inform the complainant of the availability of supportive measures with or without the filing of a formal complaint, and explain to the complainant the process for filing a formal complaint. Now, my guess is most of you have an initial response concept, something that you do when you first have a report of sexual misconduct. And most of this you probably already do, but now it is explicit in the law that as a floor, you have to do at least these things. Scott, this is a complicated concept, and I think it's confusing. You know, I've seen a lot of discussion in the press, you know, if you're deliberately and if you're, you know, is this such a low bar that as long as someone's not totally deliberately indifferent, meaning a school, you know, they're passing the test? Any additional guidance you can offer us here?
So very, very simple guidance. So the answer is no. So as you mentioned, deliberately indifferent is a different standard, but every known allegation of sexual harassment still needs to be responded to. So the deliberate indifference standard does not relieve institutions of their obligation to respond. So that's about as clear as the department can be on that one. And then second, in the absence of a formal complaint, and this is actually in the regulations, but it bears emphasis, are there circumstances where an institution would initiate a grievance process against the respondent to avoid being deliberately indifferent? And the answer is yes. And the department said, even without a formal complaint, an institution can be deliberately indifferent. So as part of a non-deliberately indifferent process, the Title IX coordinator may sign a formal complaint, which would initiate a grievance process against the respondent, even where no person alleges to be the victim and no person wishes to file a formal complaint. And that gives a few examples: threats, serial predators, violence, or weapons as instances where a Title IX coordinator may review the facts and decide that as part of a non-deliberately indifferent response, they would still need to initiate a grievance process.
I'll ask you guys this. We don't have this as a prepared question, but I'll throw this out for Scott, you, and Leslie. I mean, it strikes me, we're talking about a lot of things, all this, you know, this flexibility around policies and the challenge of developing policies. But this particular concept of deliberate indifference and the complexities around it strike me as primarily legal complexities that will likely be fleshed out eventually in court, and probably not complexities that impact your policy making. And what I mean by that is I don't know any schools that are going to look and say, well, we need to design a policy that is just north of deliberately indifferent. Right? I mean, my expectation is if you are designing policies and frameworks that comply with all of these other provisions, you know, all the things you have to do in a formal complaint, when you're looking at what you've already got, which for most institutions is quite robust and reflects state laws and the Obama era guidance, you know, this concept of needing to design the policies against this standard probably doesn't mean a whole lot, right? It strikes me that, again, where this is really, the rubber is going to hit the road on deliberate indifference is going to be if you get sued and you end up in court having to establish that your response was not deliberately indifferent.
This is Scott, and I think that that's absolutely right. And I'll just point out one thing the department really emphasized over and over is the part of the definition that it's clearly unreasonable in light of known circumstances. So doing your analysis, you have the facts in front of you. We would encourage you to document those facts, explain why you made a decision, explain why you think it's reasonable. And if it just happens that there's a fact that you don't know at that time and you get sued because of it, it's unreasonableness as what you know at that time. So hopefully that gives a little comfort that you don't have to kind of predict with a crystal ball what's going to happen next or all the claims that could come out. It's kind of doing the process, taking account all you have and know, and then making a decision that you think is reasonable.
Yeah, I think where it's probably trickiest is when you don't have the filing of a formal complaint. Because if you have the filing of the formal complaint, as we're going to discuss in a minute, I mean, there are lots of things that you're required to do, and it is extensive in the way of documentation and record keeping and how you're going to run that process. And if you go through that and manage everything in accordance with your obligations under Title IX, there's certainly going to be a lot you will be able to demonstrate to a court regarding how you responded in a very fulsome way. I think the tricky part is when you don't have a formal complaint and institutions are deciding what to do, making sure that your response satisfies these handful of specific parameters and stays north of that requirement. Okay, good. So let's talk about, so again, we're still in this area. You've got actual knowledge of Title IX sexual harassment, but you don't have a formal complaint yet. One of the things that the department talks about doing, they talk about interim measures, and then they talk about supportive measures. By interim measures, we're really talking about something you might do prior to receiving a formal complaint or even prior to a formal investigation and hearing and a determination. So the department is specific. They say an institution would be permitted to remove a respondent from campus on an emergency basis. So there is an allowance here for action prior to an investigation or a hearing on the part of the institution, provided, and keep in mind, one of the themes of this administration and their approach to Title IX has been treatment of respondents. So what they're saying is you can still move somebody off, but if you're going to send somebody home, you're going to have to satisfy certain criteria, right? So provided that the school undertakes an individualized safety and risk analysis, determines that an immediate threat to the physical health or safety, so not just emotional or mental health, but the physical health or safety of any student or other individual arising from the allegations of sexual harassment justifies the removal, provides the respondent with notice and an opportunity to challenge this decision, that means the emergency removal decision, immediately following the removal. And the regulation goes on to say an institution also would be permitted to place a non-student employee respondent on administrative leave during the pendency of the grievance process. Scott, so what's the preamble have to say?
So this is a place where the preamble really goes into detail. And we sure don't have time to address everything here, and we pointed 4 areas that we think are important, but to the extent you ever have to go through this process, we'd really encourage you to kind of do a deep dive into those provisions because there is a lot of substance there. So first, the general purpose. So the preamble explains emergency removal is for the purpose of addressing imminent threats posed to any person's physical health, which arise out of the sexual harassment allegations. So imminent threats have to arise out of the sexual harassment allegations. So as Aaron mentioned, you need to do an individualized safety or risk analysis. So under this analysis requirement, institutions can't remove a respondent unless there's more than a generalized, hypothetical, or speculative belief that the respondent may pose a risk to someone's health or safety. The department explains it does not believe it's necessary or appropriate to require a time frame for when the recipient must undertake an emergency removal because the risk arising from sexual harassment allegations that may justify removal can arise at any time. So also, the preamble addresses what it means that the individual can challenge their removal immediately. So the term immediately here, as you'll see, is a common theme, is fact-specific, but it generally understood in the context of a legal process as occurring without delay and as soon as possible, given the circumstances. So the preamble clarifies, helpfully, this doesn't mean minutes, but is more urgent than reasonably prompt timeframes, as Aaron will discuss later, that govern the grievance process. So self-harm is another tricky issue, especially for those out there who've been following the ADA direct threat analyses that have been going on for the past few years. But under this analysis, under Section 106.44c, self-harm is a ground for emergency removal. So it refers to that section refers to a threat to the physical health or safety of any student or other individual. So this provision, Ed says, does encompass a respondent's threat of self-harm, as long as the threat arises from allegations of sexual harassment. So Ed made clear to align this term with the same language under FERPA's health or safety exception. But a note of caution about the ADA. So if you look at that section, there is a savings clause that says that the section needs to be read and can't prevent someone from exercising their rights under the ADA. And the ADA's version of the direct threat language refers to a direct threat to the health or safety of others. And that clearly doesn't encompass self-harm. So to the extent that you have a situation where this provision and the ADA direct threat language are applied at the same time, just caution institutions to really kind of dig deep and look at both laws and make sure you're abiding by both. So do respondents who are employees receive the same due process protections with respect to emergency removals? And the department says generally, the answer is yes. Again, here's a place where I'd encourage you to read the commentary because it gets a little tricky when you talk about student employees versus employees that are students. But just want to make clear that employees would be covered under this section as well.
All right. So that was interim measures, things you might do between receiving or having actual knowledge of that Title IX sexual harassment and receiving a formal complaint or initiating any further process. The other thing, of course, in addition to those sort of interim measures, are supportive measures. And there's been a lot of conversation around the notion of supportive measures, though I think at this point my impression is many institutions have become quite accustomed and adept at providing these types of supports. The department goes into it specifically and gives some examples, and here the language is very similar to what was in the proposed rule a couple of years ago, if you did review that. So supportive measures, and here again we see the theme from this administration of trying to not to focus on the complainant entirely, but to take sort of this middle-of-the-road view. Supportive measures means non-disciplinary, non-punitive, individualized services offered as appropriate, as reasonably available, and without fee or charge to the complainant or the respondent before or after the filing of a formal complaint. So there's a couple of ors there that are important, right? So we're talking about the complainant or the respondent, and we're talking about before or after the filing of a formal complaint, or where no formal complaint has been filed at all. So again, these are things you might put in place even in the absence of receiving a formal complaint, just after having that actual knowledge. Such measures are designed to restore or preserve equal access, and this is the department telling you what they mean, at least in the Title IX context. They are designed to restore or preserve equal access to the school's educational program or activity without unreasonably burdening the other party. And this is an important point too, because one of the questions, at least I have frequently received over the years from institutions, especially as courts have, there have been decisions that have come down the line about measures being taken against respondents before an investigation or hearing that were ostensibly viewed as punitive, right? Here the department's saying, look, you can burden someone, including the respondent, right? But it can't be an unreasonable burden. So if you need to ask one party or the other or both parties to change their class schedules or what have you to try to keep them separated, I think most folks would take the view that that's not an unreasonable burden, and that is something that would fit here within what the department's talking about, including measures designed to protect the safety of all parties or the school's educational environment or to deter sexual harassment. Examples of supportive measures, the department offers up a number. I won't go through all these. Most of them you're probably familiar with, and again, this mirrors what was in the proposed rule almost identically in this case. The one thing I will highlight is in the middle. When the department talks about placing restrictions on contact between the parties, they do, at least in their example, sort of emphasize this notion of mutual restrictions on contact between parties. Although I believe there is some additional conversation in the preamble about potentially having like a one-way restriction order or something along those lines. Finally, the school must maintain as confidential any supportive measures provided to the complainant or the respondent to the extent that maintaining such confidentiality would not impair the ability of the school to provide the supportive measures, right? So obviously, if you're going to ask both parties to amend their schedules, they're going to know that has occurred. You can't do it without talking to them about it. The Title IX coordinator is responsible for coordinating the effective implementation of these supportive measures, which is not news to anyone, but the department does make it explicit in the regulation. Scott, I see the gold star, so I'll pitch it to you.
Thanks. So let's talk about that. Can a school offer one-way no-contact orders even though the actual language of the statute says mutual? And the answer is yes. So the department makes clear the list that Aaron provided in the boxes in the previous slide is not exhaustive, it's just illustrative. And schools should go into a fact-specific inquiry about whether carefully crafted no-contact order restricting only the actions of one party would meet the definition of supportive measures, excuse me. So a few examples of when that could happen: to help enforce a restraining order or a preliminary injunction, or if the order doesn't unreasonably burden the other party, then a one-way no-contact order is appropriate. Similarly, if a school needs to undertake emergency removals and a no trespass order is required, that is considered a one-way no-contact order by the department that would be permissible. So similarly, the department explains that there also could be instances where it's not possible or it's impractical to provide supportive measures. So the two examples provided: if an institution receives an anonymous report, it would not be possible to provide supportive measures, or you have instances where a complainant just refuses the reasonable supportive measures the institution offers and instead insists the recipient take punitive action, then it would not be reasonable or practical to provide supportive measures. The department does make clear, and always good advice for everything, if you do not provide supportive measures, make sure to document the reasons to show your response is not clearly unreasonable in light of known circumstances. Just because this is a specific element of deliberate indifference under the department, so important to document it contemporaneously so that if there is an issue, you have that to rely on. And last, a school is not obligated, but can, offer supportive measures to respondents. Back to you, Aaron.
Very good. All right, so the good news is we are at the halfway point. You've made it 90 minutes in. If you are halfway through your bottle of wine, just a reminder to maybe drink a glass of water while you're listening to the remainder of the presentation. If you think back to the nested tables, right? So now we're moving in to the innermost box. We're going to start talking about the rules that apply to the management of formal complaints, where you've received a formal complaint of Title IX sexual harassment. All right. So first, let's talk about what is a formal complaint. I mentioned this is one of the new definitions. A formal complaint means a document filed by a complainant or signed by the Title IX coordinator alleging sexual harassment against a respondent and requesting that the school investigate the allegation of sexual harassment. The phrase document filed by a complainant, incidentally, is also defined by the department and means a document or electronic submission, such as by electronic mail, through an online portal, etc., that contains the complainant's physical or digital signature or otherwise indicates the complainant is the person filing the formal complaint. Where the Title IX coordinator signs a formal complaint, the Title IX coordinator is not the complainant or otherwise a party, right, and must comply with applicable Title IX requirements. Scott.
So probably clear from the definition, but just to especially clarify. So unlike a report, a complainant cannot remain anonymous when filing a formal complaint. So if the complainant desires to initiate the formal grievance process, they have to provide the notice of allegations, including name and facts and details. And Ed's position on this is that it's a fundamental fairness and due process requirement. A respondent should know the details of the allegations made to the extent the details are known, and that provides the respondent adequate opportunity to respond and make their arguments.
So fair to say, when schools are having conversations on a go-forward basis about Title IX sexual harassment and they're explaining the process, one of the important things they're going to have to explain to complainants is this inability to remain anonymous in the context of a formal Title IX proceeding.
Absolutely. And so it's probably helpful to explain the realm of options. So the complainant can completely remain anonymous, or the reporter can remain anonymous, and they'd be unable to get supportive measures. They could report, but keep their identity confidential, and they can get supportive measures, but not initiate a grievance process. Or, as we mentioned, to file a complaint, they'd have to provide all the details of their identity and the incident that occurred.
And I don't want to digress too much here, but I'll just say as a side note, I think whoever at your institution, presumably it will be your Title IX coordinator, but whoever is tasked with explaining these options to complainants, whether that be orally or in writing, it's going to be harder to do because the options likely are going to be more complicated. You know, and this goes back to the conversation, Leslie, you and Scott and I were having earlier about, you know, all the different competing interests and whether you actually have multiple policies. One advantage of having a single policy approach or a close to single policy approach would be that it's probably easier to explain. But, you know, as we noted earlier, there are those disadvantages. If you do end up with a more complicated approach than you have had in the past, just keep in mind it's going to be harder to explain and you're going to need to spend more time thinking about how to do that so that those explanations are effective, particularly in that time of potential crisis for a complainant. Okay, formal complaint. Couple more notes. At the time of filing a formal complaint, a complainant must be participating in or attempting to participate in the education program activity of the school with which the formal complaint is filed. And Scott touched on this earlier in the presentation, but you know, this means if you have someone who is now they can file the complaint, but if they want, or they can make a report, and you may have actual knowledge of that Title IX sexual harassment and obligations to respond. But if they actually want to file a formal complaint, they're going to have to be someone who is participating in program activity or attempting to. And if they're not, you know, then the question becomes, do you have an alternative process for them that's not a Title IX process? It's complicated, right, Scott? And it's another area where schools are going to have to think about how they want to approach this potential situation where they have someone who, you know, may have just graduated or who's withdrawn and now wants to file a formal complaint.
Absolutely. Yeah, no, I think we're touching on this so much because it is complicated, and it may honestly be one of the first things that when you develop your Title IX working group to figure things out, that on that list to kind of determine what your overall intent and scope is for how to handle these issues.
Let's see. And finally, a formal complaint may be filed with the Title IX coordinator in person, by mail or by electronic mail, and by any additional method designated by the school. So there is a framework for managing these formal complaints after they come in, and this is one of the big features of the rule. I know like I said, we're halfway here, and we're just now getting to this framework, but sort of conceptually, philosophically, this is probably the primary feature of this new rule. For purposes of addressing formal complaints, a school's grievance process has to comply with 34 CFR 106-45. So if it's Title IX sexual harassment, to comply with Title IX, you've got to have a formal complaint process that complies with 106-45. Any provisions, rule, or practices other than those required by the section that a school adopts must apply equally to both parties. So this is an interesting point. The department is allowing for the notion, and I don't mean outside of your Title IX process. I mean the department is allowing for the notion that within your Title IX process, you might raise the bar. Remember, these rules represent the ceiling, so you might add additional things. But they are saying if you're managing a Title IX sexual harassment formal complaint, as a minimum, you have to comply with 106-45. And if you do add additional provisions, rules, or practices, they have to apply equally to both parties. And again, this is consistent with that theme of this administration wanting to create a rule that in their view treats complainants and respondents equally. So this is the framework. Don't be overwhelmed, but if you go through the regulations, this is literally how they break out. So when you get into this part of 106-45, it's B. If you look down here at the bottom where we have the citation. So this is 106-45B, right? It's broken down in this way, and it starts by detailing 10 basic elements that have to be in your formal complaint framework. Then it talks about notice of allegations, complaint dismissal, consolidation of complaints, investigations, hearings, which is where we get into cross-ex, determinations, appeals, informal resolution, and record keeping. And I have just outlined essentially the remainder of this presentation. So we're going to march through each of these sections and talk about what it is the department says has to be in there in each bucket. So first, let's talk about these sort of 10 basic elements. One, you have to treat complainants and respondents equitably. Again, going back to the theme we've talked about here several times. Two, you have to require an objective evaluation of all evidence and provide that credibility determinations may not be based on a person's status as a complainant, respondent, or witness. So this has to be in your policy. It's something you'll have to train folks on. Three, speaking of training, you have to train coordinators, investigators, and adjudicators, as well as folks involved in an informal resolution process, and require that they be free of conflict of interest. These training obligations are going to be significant and probably go beyond what many folks are currently doing. Further, and this in and of itself is a really interesting and complicated requirement, the department is actually requiring institutions, they're saying any, and this is in the rule, the law itself, any materials used to train Title IX coordinators, investigators, adjudicators, and any person who facilitates informal resolution must not rely on sex stereotypes, must promote impartial investigations and adjudications of formal complaints and sexual harassment. So we've got a slide here, and I'm going to let, or ask Scott, you and Leslie sort of go through this and think about this. But these are the training requirements grouped by who they apply to.
Absolutely. And so just in this first bucket is Title IX coordinators, investigators, decision makers, and any person who facilitates an informal resolution process. And they have to be trained on the definition of sexual harassment, the scope of the institution's education program or activity, and likely how you define it, how to conduct an investigation and grievance process, including hearings, appeals, and informal resolution processes if you choose to have one, and how to serve impartially by avoiding prejudgment of the facts at issue, conflicts of interest, and bias. So an institution must also ensure that adjudicators, decision makers, receive training on any technology to be used at the hearing and on issues of relevance. Excuse me, sorry, I lost my place. Relevance of questions and evidence, including when questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant. I know institutions have had these rules in the past, and this is the quote-unquote rape shield definitions and laws, but the department is here explicitly mandating institutions have these rape shield protections in place, specifically defines them as not relevant, and ensures that you need to have them trained. And last, I think I went a little out of order here, but the second one on the buckets, the institution must also ensure that investigators receive trainings on issues of relevance to create an investigative report that fairly summarizes relevant evidence. But before leaving the slide, I want to quickly address two topics.
Sorry.
Very quickly. So do the regulations define relevance? We're talking about relevance a lot here. So no, so they don't. They kind of use it's a commonly understood term, but they do provide it in the preamble. They allude to what relevance is, and I'll quote here. So evidence pertaining to proving whether facts material to the allegations under investigation are more or less likely to be true, say, i.e., what is relevant. And that's pretty consistent with the Federal Rules of Evidence definition, but the fact that the department does not define it means institutions have some discretion, but within an understood framework. And so, as we'll discuss again later, so relevance is really the only standard, in addition to a couple exceptions, that applies to these regulations. And any evidentiary rules that an institution chooses to implement must respect the standard of relevance. So an institution, the preamble says, may not adopt a rule excluding relevant evidence because that evidence would be unduly prejudicial, concern prior bad acts, or constitute character evidence. So that being said, the institution can adopt rules of order and decorum to forbid badgering a witness, and may deem, this is important, an institution can adopt a rule that deems repetition of questions to be irrelevant. And I think that could be very helpful for decision makers in your field. And sorry, Aaron, you mind going to the next slide, please?
Yep.
So Leslie, I'd love to kind of get your opinion, since we're talking about training, and I know we alluded to this earlier. But let's just start with the first question. Do you have any thoughts about best training practices that you can share?
Yeah, Scott and Aaron and everyone listening, this actually I think could be an entire webinar all of its own. There's so much to say on the topic of training. And I feel really lucky to have been trained by an amazing group of professionals in the role I played as adjudicator and advisor. There's so much that's relevant to being a participant in this process. And for people who participate the way I did, which was an add-on to my full-time role, it was really important that the trainings were well-timed to fit in between all of the other obligations I was carrying in my full-time role. It was also really helpful that the trainers ranged in professional capacity. So we heard from a variety of different kinds of professionals across the university and the community. So we heard from outside counsel who tried to help us understand the legal rules and how they unfold in practice. We heard from medical professionals. We heard from staff at rape centers or trauma centers. We heard from students to understand what they were experiencing, what their culture around sexual activity and exploration and identity was like. And we also heard from, of course, the conduct professionals within the university. And I would say one of the best aspects of the training we received, which I would highly recommend if you're thinking about developing training or looking for training to purchase for your institution, is to look for training modules that involve both the delivery of content, so conceptual education, but also opportunity for application. Because ultimately, what really matters is understanding not just what needs to be considered, but how to consider it within the context of a Title IX case. From a practical perspective, in terms of best practices, I would say anyone participating in a Title IX process needs to meet an annual training requirement. So to the extent that you don't already have an annual requirement of X number of hours to be a Title IX adjudicator or an advisor, I would recommend that. I think it's important to be constantly learning and growing in your role. In terms of how often the training sessions should occur, what the substance of them should look like, I would say keep them relatively short, 75 minutes to 90 minutes, and frequent, so that participants can sort of pick and choose amongst a panel of offerings to meet their hours and training requirements, but can do so at times that are conducive to any other professional obligations or personal demands on their lives. And now that we're all pretty much working in a virtual world and exploring all those sorts of technologies, there's really an open sort of playbook for how you can deliver the content and engage with people who aren't able to be present in the same physical space. I would say the training requirements or the content for training should include but not be limited to the topics that the regs require. I would say some of the most valuable and important areas of training I received, both conceptually and in application, were around consent, capacity to consent, specifically training on alcohol use and abuse, sexual identity and exploration, the use of social media, and culture around that are just a few topics I found incredibly useful when we started to dig into some of the facts and circumstances of the cases. And I think that's especially true if you are an adjudicator or an advisor, dealing with students who are a generation or two generations sort of behind you, right? A lot has changed in the world for students, both at the undergraduate and graduate level, than from when many of us serving as decision makers went through similar experiences, and really understanding what the university or school life or experience is for the population you're dealing with. And again, we're focusing a lot on students. This is, I think, not dissimilar from understanding the evolution of places of employment, if you're talking about employees as well, but especially when you're thinking about students, really understanding sort of the evolution of that culture. Additionally, I think, and it's embedded in the requirements, training on how to make trauma-informed decisions and decisions that are as free from bias as possible is so important. And that's, I think, really where the simulated trainings come into play, because it's one thing to really understand conceptually that we all come to the world with bias. It's a whole nother thing to see your bias play out when trying to evaluate the facts and circumstances of a case and come to decisions regarding liability or responsibility. And if your process involves sanctioning, understand where your biases come in with respect to sanctioning as well. And so again, I come back to that idea that it's not just about the concepts, but mostly about the application. And, one of the best ways to learn is actually, quote unquote, on the job training. You learn a lot by being a panelist. And so I think there's something to be said for also just, giving your adjudicators the foundation they need, and then ensuring that they are coupled with more seasoned adjudicators when they're sort of newbies in the field to learn on the job, because a lot of the training and the learning just happens by doing, by necessity, especially if you're in an environment like I was where you serve as a volunteer.
Thanks, Leslie. That all makes sense to me, and I sure think that, especially to your point of just on-the-job training and mock hearings are really valuable, and you can really kind of throw the gamut of any issue that difficult issues that hearing board members might see at your team.
Yeah.
Also want to talk about we'll talk about trauma-informed training, because the preamble does have some pretty interesting things to say about that, and the neurobiology of trauma a little later in the presentation. So stay tuned for that. But mindful of time, and I think we could kind of combine 2 and 3 together. But just really interested on your process of how board members might be trained on difficult legal concepts, considering not everyone is a trained lawyer like you are, and some qualities that you might think of for board members and presiding officers.
Yeah, so it's sometimes hard for me to put myself in a non-lawyer shoe, because that's just not who I am. I happen to be a trained lawyer, even though I haven't been a practicing lawyer since 2004. And so, I think the best advice I can give is, keep the learning short and manageable and as simple as possible. Really think, and sometimes lawyers are actually really good at this. Outside counsel can come in and do a really nice job providing a training on, breaking down the rules of law and explaining them, because that's what they have to do to their clients, right? They have to, generally in the business, explain rules to non-lawyers. So I think there's a role there for training people who are not lawyers. And then, again, recognizing that a lot of the training happens on the job. So trying, when you're putting together, if you have a process involves a panel, multiple adjudicators on a single case, really thinking about having sort of a more seasoned adjudicator, or if you can, one of the adjudicators be a lawyer who can help others come along. And I've really had the pleasure, actually, of watching some of my colleagues grow into their roles as adjudicators. And it was really amazing how people can pick up concepts that they have not been trained to understand. Another way of thinking, especially when you're looking at people within a university, is that there are lots of jobs within academia that require an understanding of rules and implementation of those rules to do their jobs: registrars, other student service professionals. So there are lots of places where people are used to interpreting and applying rules and enforcing the rules. And so those are good populations of people to look to bring on as hearing panelists or board members, because they're used to that idea of interpreting and applying and enforcing rules. And in the interest of time, to jump right to that last one, I think that's the number one piece of advice I can give about selecting board members is you have to pick people who are comfortable with ultimately enforcing the rules that your community sets in place. It doesn't do you any good to bring in people who, when push comes to shove and they have to make decisions of responsibility, or if your process involves sanctioning, make decisions of sanctioning and get cold feet. That can be really detrimental to the process and ultimately doesn't serve the university well. So you really need people who understand their role and responsibility to keep the community safe, and who ultimately are going to carry out whatever the rules are going to be for your process, and feel comfortable and confident that they're doing that on behalf of the university, even if some parts of it feel really challenging because it's having a negative impact on an individual involved in the process.
Perfect. These are all great points and lots to consider. I'll toss it back to Aaron now.
Yeah, and I'll just as a point of clarification, when we're talking about board members in the context of this conversation, we are talking about hearing board members, for example, your adjudicators, not your board of directors of your college, university, or institution, although there certainly are times when those individuals also will receive training on Title IX and discrimination policies and things along those lines. All right, so remember, we're in this first sort of piece of the framework, and it's these 10 basic requirements, and we talked about 1, 2, 3. We'll go through the remainder a little more quickly. You have to include a presumption of innocence for the respondent. In other words, innocent until proven guilty, and that has to be in your policy. You have to include reasonably prompt time frames for resolution and allow for temporary delay or limited extension for good cause. There was guidance under the Obama administration that matters should be resolved in a particular number of days. Here, the department's not giving you a specific number of days. They're saying reasonably prompt. And frankly, and I think one of the things, by the way, as an aside, that schools are really going to have to figure out, and I know in talking with some of our clients already, one of the concerns about this rule is just getting through this process in a reasonably prompt fashion could be challenging because of all the complexity of the process itself. Describing the range of sanctions and remedies, again, that's in the framework, in your policies itself, you need to do that. You need to detail the standard of evidence and provide for consistent use of that standard of evidence in dealing with all formal Title IX sexual harassment complaints, whether that's students or employees. Now, this has been a real hot button topic, right? Which standard of evidence to use? And the department here is giving schools an option. It says they can use either preponderance of the evidence or clear and convincing, though there can still be complexities in applying that type of flexibility in the context of your own policies. And to talk about that, Scott, I will kick it back to you.
Sure. And just very quickly, the regulations don't provide a definition of preponderance and clear and convincing. So there's some allusion to case law in the preamble, but just the general legal definitions are expected there. And the department makes clear that preponderance or clear and convincing, they don't take a position on either. They think a hearing can be adjudicated fairly using either standard. The standard of evidence, they explain, reflects the degree of confidence that the decision maker has in the correctness of the final conclusions reached, and that schools will select a standard of evidence based on which one serves the interests of the recipient's educational community best. But, as Aaron mentioned, there are some caveats. Sometimes state law requires the recipient to apply one standard or the other. Or you could have a collective bargaining agreement or a faculty handbook that you already have a standard listed in. What the department does say is that you have to use a consistent standard regardless of misconduct proceedings. So students, employees, faculty, whatever category of individual at the university, the standard has to be the same. So to the extent that you have a state law requirement that requires students to be adjudicated under preponderance, then likely you're stuck with preponderance for employees. If you have a collective bargaining agreement that says that you've agreed to clear and convincing, but you want to move to preponderance, you'd have to renegotiate your collective bargaining agreement prior to August 14th, or use the clear and convincing evidence. So it's an interesting deal, but again, this is another one of those big topics when you're kind of developing the policies forward. Make sure you take a look at your state law, any agreements that you've signed, CBAs, any faculty handbooks, and really take a look at those standards and see if you're committed to one or the other. And if you're not, then kind of whatever best standard applies to your institution, the department's okay with that.
Yeah, and I'll just, alluding back to one of the wrinkles we talked about earlier, we're talking about you have to use the standard of evidence consistently across all formal Title IX sexual harassment complaints. In theory, if you have a separate process and set of policies for non-Title IX sexual harassment, you could ostensibly use a different standard of evidence. But then I think you get into the issue that Leslie articulated earlier, which is, do you really want a situation where you're using a different standard of evidence in matters, for example, that both involve some form of sexual harassment and both involve students? And I think there are all other types of issues you could run into if you do have different standards in play. So again, as Scott said, all things you're going to have to consider and think through. Rounding out our 10, describe the appeal process and standards. Describe the range of available supportive measures. Again, this is all stuff that just has to be in your formal complaint procedures. And finally, they have to, those procedures themselves cannot require, allow, rely upon, or otherwise use questions or evidence that constitute or seek disclosure of information protected under a legally recognized privilege. So in other words, you couldn't have a process that required the disclosure of attorney-client privileged information, for example. So that quick 10, those basic 10, were the first, remember, of our list of things that have to be in your framework. So the second thing that has to be in your framework is an appropriate notice of allegations. The department has indicated in the new rule, upon receipt of a formal complaint, schools must provide a written notice to parties that includes discussion of the formal complaint process, including any informal resolution option. And then they've said, look, a sufficiently detailed statement of allegations has to include a number of things. The identity of the parties, if known, conduct allegedly constituting sexual harassment, and the date and location of the alleged incident, if known. Also, statement that the respondent is presumed innocent and that a determination of responsibility is made at the conclusion of the process. A statement regarding the right to an advisor and to review and inspect evidence, and a reminder that the school prohibits knowingly making false statements or knowingly submitting false information. All of these are things, for the most part, I think that if you are consulting your attorney or general counsel, they would suggest should be in a sufficient notice anyway. So I don't think there are many surprises here. I have a fire truck going by outside my window. I hope that's not too loud. Parties must be provided sufficient time to prepare a response before any initial interview. So remember, if you're going to send out, and sometimes I have dealt with clients where, you know, the Title IX coordinator has gone and conducted, or an investigator has gone and started to conduct initial interviews before that notice goes out. And it's important to keep in mind that the notice needs to go out first, and that's in the rule here. Parties must be provided sufficient time after receiving the notice to prepare a response before the interview process begins. Schools also must provide updated notice if the school decides to investigate allegations about the respondent or complainant. I thought that was interesting. This is in the law, or complainant, that are not included in the initial notice. And this is a fundamental concept when you have conversations around due process or fundamental fairness. You know, if you provide someone a notice and it says these are the allegations, and then you begin conducting the investigation, and in the course of the investigation other allegations surface, you know, additional sexual misconduct is alleged, and you decide to investigate that as well and make it potentially part of a determination with regard to that respondent, or again, there could be allegations or initial, you know, additional facts about even the complainant that come to arise. You have to reissue your notice to make sure that you're letting them know now we're considering these initial allegations, because the problem is if you don't, and then you end up in a hearing, they could be in a situation where they're being asked to respond to allegations and they didn't know those allegations were even on the table, right? But this is one of those things that sometimes schools will slip up on. And it's something, now it's in the law, but it's something really should have been aware of, and hopefully we're doing already if you were managing these types of issues. Let's talk about complaint dismissal, because there are express circumstances in the new rule where the department allows you to dismiss a formal Title IX sexual harassment complaint, and there are also circumstances where you are required to do so. So a school must dismiss a formal complaint of Title IX sexual harassment, right, for purposes of sexual harassment under Title IX, if the alleged conduct would not constitute sexual harassment, even if proved, did not occur in the school's education program or activity, or did not occur against a person in the United States. So really what the department is saying here is, look, if you assume that all of the facts alleged are true, accurate and true, and the alleged conduct still would not constitute Title IX sexual harassment under that definition we've got there, which requires, right, that it be in a program or activity, that it occur against a person in the United States, then you have to dismiss it for Title IX purposes. But The department also emphasizes such as dismissal does not preclude action under another provision of the school's code of conduct. So again, what the department is saying is here, we're setting the floor. We have articulated a definition of what constitutes Title IX sexual harassment. If you determine that whatever is being alleged does not satisfy that definition, even if you assume all the facts are true, if it still wouldn't satisfy that definition, then you've got to dismiss it as a Title IX sexual harassment formal complaint. But you could have a mirror process and still proceed under that mirror process, right? And it could look ostensibly exactly like your Title IX process, right? But it's not a Title IX formal complaint anymore. It's outside of that. And again, this goes back to my comment at the very beginning. I think a lot of this is going to force schools to sort of start thinking about things very specifically in terms of what's a Title IX formal complaint and what's not, because if you find yourself in this situation and you dismiss, you're going to have to document very clearly and communicate to the parties that this has been dismissed as a Title IX sexual harassment formal complaint, and you're no longer proceeding under the policies that govern those types of complaints. But you may still be proceeding under some alternative set of procedures that are significantly different or could even be identical to your Title IX process. Okay, what about optional dismissal? Schools may dismiss a formal complaint of sexual harassment if at any time a complainant notifies the Title IX coordinator in writing that they'd like to withdraw, if the respondent's no longer enrolled or employed by the school, and I know that's a situation that can occur with some regularity. Something occurs right at the end of a term, or something occurs with an employee who subsequently moves on. Or specific circumstances prevent the school from gathering sufficient evidence to reach a determination. Upon a required or optional dismissal, schools must promptly and simultaneously send written notice to departments. And frankly, I mean, if you're electing to dismiss or you're required to dismiss, I mean, you're going to want to document all of that very thoroughly. By the way, speaking of documentation, I'll also go back to Leslie was talking earlier about training and having optional trainings and, maybe various modules folks could choose from. But keep in mind, you have to be able to demonstrate potentially to the Department of Education that those folks have received their training. So whatever training modules you come up with, you need to document that those are available and make sure that you are documenting when they're completed by individuals, right? So you want to be able to demonstrate that whoever's engaged in your adjudication process, your Title IX coordinator, et cetera, have actually gone through that training. So it's not just enough to have it and that they do it. You got to be able to demonstrate that you have it and that they did it. Okay, dismissal of complaints. Scott, over to you.
Thanks, Aaron. And really just the commentary I wanted to add here, just to help explain that the department's position is that they just don't have authority to require recipients to investigate and adjudicate certain things, including conduct not covered under Title IX. And so they here say you can kind of, if it's outside of the scope, you could investigate in the manner the institution seems fit, but they take the position, probably correctly, that if it's not provided under Title IX, it has to be dismissed by law, per se. Next slide, please. And then a few just basic questions that come up. So must schools always investigate a formal complaint of sexual harassment? And the answer is yes. The department believes that when a complainant's chosen to file a formal complaint or the Title IX coordinators decided to sign a formal complaint, the institution must investigate those allegations. The circumstances when a mandatory dismissal is applied. So Aaron mentioned the kind of the legal prongs, but the preamble goes on to explain that institutions should look at where the allegations, if true, would meet Title IX's jurisdictional conditions. So for those familiar with litigation, this sounds a lot like a motion to dismiss standard. And for just like litigation, it's a really interesting question that schools are going to have to grapple with. So there'll be some really easy ones, just cases where someone alleges something completely outside the bounds of the definition. So someone alleges I was sexually discriminated against because they thought I was a Mets fan. So obviously that's an easy case. It's not sexual harassment. It's a mandatory dismissal. But the closer call is whether harassment is severe, pervasive, or objectively offensive. And if it's on that line, do schools really feel comfortable making a mandatory dismissal decision? And I don't have a good answer for you right now, but just something for you to think about, that it might not always be clear when a mandatory dismissal is required. And for discretionary dismissals, recipients should not apply a discretionary dismissal in situations where the institution does not know whether they can meet the burden of proof. So what you don't want to do is make a premature determination that allegations lack merit or frivolous. That's not the purpose of the dismissal process. That should go to the decision maker for final adjudication. And last, so if the school is required to dismiss a complaint, I think as Aaron said, can it still be investigated and adjudicated under alternative procedures? Absolutely, in any matter the institution seems fit. Back to you.
All right, so there is a little bit on complaint consolidation. I've just got one slide here, but the department does say, and I think a lot of schools do this, and it's good that the department acknowledges that it's okay to do, that you can't consolidate formal complaints provided the allegations of sexual harassment arise out of the same facts or circumstances, and the complaints are against more than one respondent, by more than one complainant against one or more respondents, by one party against the other party. So I think it's not uncommon to see these situations, and it's good that the department was clear that you can consolidate complaints in these scenarios. I want to move through investigations at a deliberate speed, but fairly crisply, because I want to get on to hearings. We got about 45 minutes left. And I want to make sure in particular that Scott and Leslie have time to talk about cross-examination, which I know is one of the biggest, most complicated and difficult pieces of all of this to sort of get the brain around. So with regard to investigations, there are requirements set out in the law, specifically, and there are sort of 5 here, 3 on this slide, 2 on the next that we'll articulate. With regard to burden of proof, you, in your complaint framework, with respect to the section on investigations, you have to ensure the burden of proof and the burden of gathering evidence rests on the school, not on the parties. Equal opportunity, you have to provide equal opportunity for the parties to present fact and expert witnesses, by the way. So the department here is clearly contemplating in the context of these formal Title IX proceedings that expert witnesses can be present and offer testimony and other inculpatory and exculpatory evidence. With regard to restrictions, you have to refrain from restricting the parties' ability to discuss the allegations or to gather and present relevant evidence. And Scott, I know you had a quick comment on this as well.
Sure, and not necessarily restriction, but the department just makes clear for everyone, the school can adopt evidentiary rules, so just consistent with the final regulations. This would not be a restriction, but a school can and should strongly consider adopting rules governing how admissible relevant evidence should be evaluated in terms of weight and credibility by the decision maker. And as most rules in this presentation, the rules have to apply equally to both sides.
Yeah, probably a better label for that box would have been refrain from restrictions. All right, notice, content, and timing. So we talked a few minutes ago about the notice investigation, and here again the department talks about in the context of investigations. You have to provide, or your investigator needs to provide to the parties, to any party whose participation is invited or expected, a written notice of the date, time, location, the participants, and purpose of all the hearings, investigative interviews, or other meetings with sufficient time for the party to prepare to participate. So you're going to want to develop template notices that you can send to folks in advance of any kind of interview or hearing that hits on all these points. And frankly, a lot of this stuff, again, is stuff that your lawyer probably told you should include anyway. And once you have those templates, this will actually help protect the institution, because it's good that you're giving people sufficient time and sufficient notice in advance of these events. Investigative report. Finally, the department notes that the investigation, part of your framework around investigations, has to include an investigative report, and it has to provide for the issuance of the investigative report in a way that fairly summarizes the evidence. On the point of confidentiality, schools, and you'll notice at the bottom, if you look at the citation, it's not actually in 10645. This comes from a later section in 106 that's actually talking about retaliation, but we wanted to talk about it and put it here because it does apply to more broadly. It says schools must keep confidential the identity of any individual who has made a report or complaint of any form of prohibited sex discrimination. So that's not just sexual harassment, right? I mean, we could be talking about anything. If somebody comes again and says, you know, I didn't get the job promotion because I'm a woman, that is a form of prohibited sex discrimination, and this confidentiality provision would apply. But we slipped this slide in here because a lot of times, you know, issues of confidentiality arise and are being given a lot of consideration in the context of investigations and hearings. So again, there is this provision. You have to keep confidential the identity of any individual who's made a report or complaint of any form of prohibited sex discrimination, including reporter, complainant, respondent, or witness, except as may be permitted by FERPA or as required by law, or to carry out these Title IX regulations. So as Scott pointed out earlier, if somebody actually files a formal complaint, right, you can't keep the complainant anonymous, right? So there are some, to comply with other elements of this law, of course, as he's pointing out and as we're demonstrating, you will have to reveal at times the names of the other individual. Okay, advisors. So the law provides, in the context of the investigation, schools must afford the parties equal opportunity to have an advisor during any aspect of the formal complaint process. So we're not to the hearing yet. We're talking about even during the investigative phase. The advisors may be an attorney, don't have to be. Schools are not permitted to limit the choice of advisor or the advisor's presence, but they may restrict an advisor's participation in the proceedings as long as the restrictions apply equally. So as I heard an attorney last week say, you know, this is the potted plant rule. You can essentially restrict the advisor's role to that of a potted plant, at least in the context of the investigation. Now that changes a little bit when we get to cross-examination and hearings. Scott, you had a comment on advisors.
Yeah, a few interesting ones from the preamble. So this is a new concept for me, but schools can, according to the preamble, require advisors to sign non-disclosure agreements. So as long as the agreement complies with the regulations and applicable law, that's something that schools should consider. Institutions could also require advisors to use evidence received for inspection and review only for purposes of the grievance process and require them not to further disseminate or disclose those materials. When we're talking about cross-examination, and we'll talk about it a little later, but this is for the advisors specifically, the preamble interestingly explains that an advisor's cross-examination on behalf of the party is satisfied where the advisor poses questions on the party's behalf. And that means that the advisor could relay that party's own questions to the other party or witness with no particular skill or qualification needed. So here I think the department's more talking about when the institution provides an advisor. But important for institutions to know that, at least for the preamble, the advisor's obligation is satisfied just by relaying the questions of the party through cross-examination to the other party. Can advisors conduct cross-examination? So the preamble says, yes, they can, but it's up to the school's discretion, and any rule must apply equally to both parties. And that also makes the point that it means advisors do not need to conduct cross-examination, which may not be a terrible rule to have. And schools should strongly consider whether they want advisors to be conducting cross-examinations and write their rules accordingly. And last, confidential information. We talked about it a little earlier, but regarding the investigator can be required or permitted by the institution to redact information not directly related to the allegations or information otherwise banned from use, for example, rape shields or privileged information that are contained within the documents or other evidence before sending it to the parties for inspection and review. And with that, I just wanted to pose a really quick question to, maybe not a quick question, but a short question to Leslie. How did you deal with overzealous attorney advisors as an adjudicator, and do you have any tips going forward?
Yeah, so, you know, the process that I adjudicated was clear that the advisors were solely to participate in a role of giving support to the parties. So the advisors actually didn't participate in the hearing process, though, you know, as a lawyer myself, it was often easy to identify a party had brought a lawyer in as an advisor just by the way that they interacted or the request for additional breaks or, whispering amongst them to answer or not answer questions in a certain way. And it was certainly obvious where a lawyer was brought in on appeal based on how the response was written, or how an appeal or a response was written. I think if you're thinking about how to serve as an advisor or who should serve as an advisor, I would tell you that while my advisees loved that I was an attorney, I think they thought that was a real bonus for them. It's not necessarily, although we may talk about this slightly differently when we talk about cross-examination and that responsibility. It's not necessarily the lawyering skills that are relevant to being an advisor, although I think they are incredibly relevant to being an adjudicator. It's the understanding of the school's process that really benefits the advisee, the party. When the advisor deeply understands what might the adjudicators be thinking, how are they going to be interpreting the rules and applying them, how are they going to make determinations of responsibility or, if applicable, sanctioning. And so that I actually think was the best perspective I could offer an advisee, was to say, listen, this is what's going to happen in the hearing, and if I were an adjudicator, these are the kinds of things I would be wondering about, and these are the kinds of questions I might ask. Where it actually got kind of complicated for me, and I really had to struggle with where the boundaries of advising was in the preparation for a hearing and helping my advisee understand what questions may or may not be asked of him or her and how he or she may respond to those questions. I think there's a very fine line between advising and leading a party to testimony. And especially for lawyers, I think that's a really hard line to stay behind if the role of advisor is defined by an institution as anything other than a zealous advocate on behalf of your party. So I would also think, to the extent that an advisor is a lawyer, there's something really important to understanding when you get to sanctioning what the schools consider when applying discipline. The process we took part in really focused on the acceptance of responsibility and respondents' ability to show understanding and acceptance and growth from any potential wrongdoing could have been a mitigating factor to reduce the severity of a sanction. And typically when lawyers got involved, you could tell that the parties were advised to avoid any and all opportunity to accept blame, which is different than accepting responsibility and showing growth. And so I would just caution, if there are lawyers out there listening to this presentation and serving in the role of advisor, to really think about how your role as advisor might be different than your role as a lawyer in a courtroom. Because while certainly when we talk about cross-examination, these processes may start to feel a little bit like a courtroom, it isn't a courtroom, and different expectations apply, and the schools may be looking to different information from the parties in order to make their decisions of responsibility and ultimately sanction.
So that's a little bit of a preview too of the hearing section, and talking about advisors and their role in hearings. And actually, I want to get to that. So this is just to be clear. Right now we're sort of talking in the context of investigations, and I want to be clear that when we talk about at the bottom of this slide, schools can restrict advisor participation in the proceedings. So proceedings also can mean, as part of the investigation, interviews and things along those lines, as well as during the hearing and adjudication itself. So in an effort to get to that, because I know that's a hot topic, let me just finish out investigations, and then we'll go ahead and get onto the cross-ex. So access to evidence throughout the investigation. So that's the investigation part. Institutions must afford both parties equal opportunity to review and inspect any evidence that was obtained as part of the investigation and is directly related to the allegations. So you're going to have to be ready to keep a record or a copy of all the evidence that you receive and determine what needs to be made accessible. And keep in mind, this includes evidence upon which the school does not intend to rely in reaching a determination. So in the past, I think sometimes folks would limit what they would only provide access to parties that was the part of a record upon which they intended to rely. But the department's very clear in the rule that that the parties have to have access to evidence upon qualifying access to evidence, even if the school does not intend to rely upon it in reaching a determination. Finally, timing of access. There are sort of 4 different rules that go to timing of this access. Generally, you have to provide access to the evidence early enough that a party can meaningfully respond to it prior to the conclusion of the investigation. So remember, we're still in the context of an investigation. Prior to the issuance of the investigative report, you have to send the parties all the evidence subject to inspection and review, so anything that falls into that sort of category of being evidence that you have to make available. And you have to afford the parties at least 10 days to submit a written response. Then, separate, so that's prior to the issuance of the investigative report. 10 days prior to the hearing or other event of determination, you have to send the actual investigative report to the parties for review. And then at and during the hearing, you have to make that evidence available. So there's lots of access here. And, when you're talking about getting through these proceedings in a timely manner, I do think that all of these sort of points where you have to send things out and wait for responses, it's going to slow things down, particularly if you have parties that aren't always timely in receiving that information and getting it back to you. Okay, so hearings. I'm going to walk through what the law says, and then I'm going to pitch it over to Scott and Leslie to get into some of the nuance. So hearings. Institutions are required to have a live hearing right out of the gates, right? The proposed rule made it optional. Many schools don't have a hearing at all right now. Let me be clear. If you have a formal complaint of Title IX sexual harassment and it is under your Title IX formal complaint process, you're required to include a live hearing as part of that process. Also, the adjudicator cannot be the same person as the Title IX coordinator and or the investigator, right? So your adjudicator or adjudicators, your hearing officers have to be independent parties. Live hearings may be conducted with all the parties physically present, or at the school's discretion, participants may appear virtually with technology enabling them to see and hear each other. Schools must create an audio or audiovisual recording or transcript. I know a lot of schools don't currently create recordings or transcripts of the hearings. Now you have to for any live hearing, and make it available to the parties for inspection and review. Adjudicators must permit, so now we're talking about specifically cross-examination. If you may just want to dispense with the wine glass altogether at this point and just grab the bottle by the neck. Adjudicators must permit each party's advisor to cross-examine the other party and any witnesses. Cross-examination at the live hearing must be conducted directly, orally, and in real time by the party's advisor and never by a party personally. So to be clear, you have to permit cross-examination, right? And that doesn't mean a party has to take advantage of it, but you have to permit each party's advisor to cross-examine the other party and witnesses. And that cross-examination must be conducted by the party's advisor directly, orally, and in real time. If a party does not have an advisor, the school must provide an advisor of its choice, meaning the school's choice, free of charge, to conduct the cross-examination. So again, just to be clear, you've got to have a live hearing. You have to permit cross-examination. If that cross-examination is conducted, if the party wants to take advantage of its right to cross-examination, whether that's complainant or the respondent, then you have to have the advisor conduct that cross-examination. And if the party doesn't have an advisor, you have to provide an advisor of your choice. At the request of either party, schools must provide for the live hearing to occur with the parties located in separate rooms. So remember, you can have it in a single, everybody all together physically in the same room. You, at your discretion as an institution, can choose, if nobody asks you to, you can still choose to use technology and separate everybody. But if either party requests it, then you must provide for the live hearing to occur with the parties located in separate rooms, with technology enabling the adjudicator and parties to simultaneously see and hear the party or the witness answering questions. Only relevant cross-examination and other questions, including those challenging credibility, may be asked of a party or witness, which means before a party or witness answers a cross-examination or other question, the adjudicator has to determine whether the question is relevant and explain any decision to exclude a question as not relevant. So imagine you've got parties in separate places. You've got technology that brings everybody else so that everybody can see everybody else. You are having to provide potentially an advisor to one of the parties for the live hearing. Maybe you have an attorney on one side. Maybe you have provided an advisor that's an attorney or you have not. And then you have to have an adjudicator who is able to vet questions, right, in advance, in real time, and make a call on relevance, and then explain to those advisors, which could include an attorney, any decision that the adjudicator makes to exclude a question as not relevant. And to be clear, this is all straight out of the law. Questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not considered relevant unless such questions and evidence are offered to prove that someone other than the respondent committed the alleged conduct or concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. So again, you're going to have adjudicators who are able not only to vet questions of relevance, but specifically sort of to take into account these nuances. If a party or witness does not submit the cross-examination at the live hearing, so like I said, if I'm a respondent, I could elect not to conduct cross-examination. It's my right, but I could say, I don't want to cross-examine. I don't have any questions. But if a party or witness, if the respondent, for example, does want to cross-examine the complainant, and the complainant or witness does not submit to that cross-examination at the live hearing, then the adjudicator must not rely on any statement that has been made of that party or witness in reaching a determination regarding responsibility. Now, by the way, we know there are lots of loaded questions in here about advisors and statements and all those things, and that's what I'm going to pitch to Scott in a minute, but I wanted to get through everything that's actually in the law. However, the adjudicator cannot draw an inference about the determination regarding responsibility based solely on a party's or witness's absence from the live hearing or refusal to answer cross-examination. So in other words, adjudicator can't say, well, since that person refused to be cross-examined or to show up, based on that fact alone, I'm going to assume that, they were responsible or the respondent wasn't responsible. Okay, so with all of that having been said, and with about 30 minutes left, Scott and Leslie, I kick it over to you guys to talk a little bit more through what is really an astounding set of requirements.
It sure is. Thanks, Aaron. Even just going through it again, I've read it a few times. It just kind of strikes me how difficult this is going to be to implement. So cross-examination is one of the most controversial and newest elements of the regulations. The commentary does a fairly decent job at providing some additional context, sometimes interestingly. But just for clarification, this piece is here to let you know Ed's intent here is to make clear that this is an adversarial process. You don't have a Title IX process without it being adversarial. And the preamble describes a number of times cross-examination as the greatest legal engine ever invented for the discovery of truth. So they are very keen on it here, and they are very hot to get it started. Next slide. Thanks, Aaron. And so some of these we've already gone over, so I won't address those questions. So I'll start with the second one. So if a party's advisor of choice refuses to comply with the recipient's rules of decorum, can the school require a party to use a different advisor? So the rules say yes, but it's sure important you consider that you'd be removing the party's advisor of choice. This is not to say you can't do it or you shouldn't do it, but you'll certainly get a challenge and an appeal. So I would just encourage you to let your adjudicators know this is an option, but to use it judiciously. So I'm going to quote the preamble about the trauma-informed approaches, because I think this is really important just to make sure you know what exactly Ed's talking about here. And Leslie referenced this earlier. But the preamble makes clear that trauma-informed approaches can be implemented as part of an impartial, unbiased system that does not rely on sex stereotypes. But doing so requires taking care not to permit general information about the neurobiology of trauma to lead Title IX personnel to apply generalizations to the allegations in specific cases. So what does this mean? It's an important point, and this was a big issue back in 2017 when this administration first took over. So schools can still use trauma-informed approaches, but the department makes clear that the neurobiology of trauma, that's a piece you should really use very carefully if you're going to. And Title IX personnel cannot apply generalizations about neurobiology of trauma to allegations in specific stages. If you're going to use trauma-informed questioning, the preamble makes clear that this can be done by an investigator, given the opportunity to make statements prior to cross-examination. But once cross-examination occurs, there's no limitation on the opposing party or counsel. The department does say that parties have the discretion to take breaks if it gets too intense or there's flashbacks or any trauma or anything like that. Nor do the regulations require answers to cross-examination to be in linear or sequential formats. Next slide, please. So I'll move through quickly. So where a party or witness does not appear at a live hearing or refuses to answer cross-examination, as Aaron said, the decision maker must disregard statements of that party or witness. And the decision maker cannot draw any inferences about the determination regarding responsibility based on the party or witness's failure to appear to answer questions. And the key concept here is the word statements, and we'll discuss that a little later in a few slides. Because if the case does not depend on the party or witness's statements, but rather on evidence, such as video evidence that doesn't consist of statements, the decision maker can still consider that evidence and reach determination. So where a complainant refuses to submit to cross-examination, but there's a video detailing exactly what happened, the decision makers can still rely on that video for that. If an advisor asks a question in a harassing, intimidating, or abusive manner, so as we talked about, schools can impose rules of decorum. However, you have to make sure that all relevant questions and evidence are still admitted and considered. So even if an advisor asks a question like a jerk inappropriately, the institution needs to still even-handedly enforce its rules of decorum, but ensure that the relevant question is asked in a respectful and non-abusive manner. If the Title IX coordinator is called as a witness, the Title IX coordinator is still expected to serve impartially without prejudgment or the facts at issue. And I think as we discussed before, but briefly again, relevant character evidence or evidence of prior bad acts on cross-examination cannot be excluded under the final regulations. You cannot exclude or refuse to consider evidence, but you could make weight or credibility determinations for that evidence that apply equally to both parties. Next slide, please. So can the school adopt rules about timing and lengths of breaks? Yes, and should do that, and you should really consider that. As well as rules forbidding participants from disturbing the hearing by loudly conferring with each other. But an institution cannot forbid a party from conferring with their advisor. If a party or advisor breaks a school rule during the hearing, can the school enforce its code of conduct? The preamble says yes, but as Aaron's going to talk about a little later, you have to be really careful not to run afoul of the retaliation provisions that are embedded in these regulations. And last on this slide, can a school adopt a rule that does or does not give parties, advisors, the right to discuss relevance determinations? The answer is yes. So in addition, if an institution believes arguments about relevance determinations during a hearing would unnecessarily protract the hearing or become uncomfortable for parties, which I assume a lot of schools would, the school may adopt a rule that prevents parties and advisors from challenging the relevance determinations during the hearings. Next slide, please. So Aaron mentioned that decision makers need to make a relevance determination. The preamble explains what's required a little bit during a relevance determination, and it explains that lengthy or complicated explanations are not required. It gives a few examples. For example, it's sufficient for a decision maker to explain that the question's irrelevant because the question calls for something such as prior sexual behavior that doesn't meet one of the two exceptions of the rape shield law, or that it's not probative of any material fact concerning the allegation. So here, for most relevance determinations, I think that second clause, that it's not probative of any material fact concerning the allegations, would be a potential way to advise your hearing board adjudicator on how to respond in making relevance determinations. In addition, institutions can adopt a rule that the decision maker will send the parties after the hearing revisions to the decision maker's explanations. So in effect, they could supplement or better explain their decisions after the hearing. Think about whether you want to do that and whether that would be sufficient cover for any litigation. But that's certainly up to the discretion of the university. Can a party's advisor appear and conduct cross-examination even when the party whom they're advising not appear? Yes. What happens where one party does not appear and the party's advisor of choice does not appear? So the advisor provided by the institution must still cross-examine the other party on behalf of the non-appearing party. If they don't do that, the appearing party statements would not be considered tested by cross-examination, and those statements would not be permitted to be evaluated by the adjudicator. If the institution's appointed advisor does conduct cross-examination, the appearing party statements would be considered. And another really interesting point, so if a complainant does not appear or does not submit to cross-examination, can the party's family member or friends recount the statement of the party? And the answer here is no. And this happens, you could think frequently, if someone's traumatized by an incident, they tell their best friend, they tell their family member, and then just can't come to the hearing. So even if that family member or friend would be subject to cross-examination, the answer is still no. Ed says it's unfair and potentially leads to an erroneous outcome to rely on statements untested by cross-examination when they're only focused on the statement, relaying the statement of the original victim. And last slide, please. Submitting to cross-examination means just answering questions that are relevant. There's the same exclusion. And then last, statements. Important to know that there's no definition, but it has its ordinary meaning. And so the important part here is police reports, SANE reports, medical reports, and other records or documents would be considered statements, and they can't be relied on to the extent they contain statements of a party who hasn't submitted to cross-examination. So that means that a police officer, a SANE nurse, or other professionals that offer reports with statements would need to appear and be subject to cross-examination, or those statements would not be considered. And that takes me through my piece about cross-examination. Aaron, do we have time for one quick question to Leslie, or are we?
Yeah, I think so. Yeah, I think so.
Okay, so Leslie, yeah, no, I sure am too, and I've talked to her a little bit about this, but just based on your experience and knowledge, and this is never applied to you in the past, in your role, what's your general impression on cross-examination and any advice you have for the current crop of people that need to administer this kind of role?
Yeah, there's, so many thoughts and responses. This process you've just explained, Scott, is so different than the process I took part in as an advisor or an adjudicator. We never had parties in the room at the same time. There were no recordings. There's a lot of new requirements that come into play. But I think what strikes me most is just the real shift to the adversarial nature of the process. As adjudicators, we were trained so deliberately on how to ask questions in a non-leading, non-aggressive, non-adversarial way, to really be respectful of what the parties were experiencing, and to, we were just trained extensively on how to ask questions of people who have or may have been through trauma, and in a way that allowed us to get the information we needed that was relevant to determination and not ask for information that was not relevant. And so I just see this as such a drastic shift in how parties are going to have to respond to questioning, and the importance of the role of adjudicator or hearing panel or board members or officers in enforcing the decorum of whatever the school sets for them. So I think, what's going to be really important going forward is that the school do a really good job diligencing who they bring in to run these processes, whether they be staff or volunteers. These people have got to have the strength and the voice to enforce whatever rules for decorum exist to make these determinations of relevance on the fly. So there's just going to be an incredible burden, I think, on schools to train participants in the process. And I think we're going to see an increase in lawyers participating in the process of advisors. I think parties are going to see the words cross-examination and insist, or at least desire, that a lawyer be their advisor, which brings, as I said earlier, a whole host of challenges, especially to the extent that the lawyers participating really don't understand the purpose of these processes, and ultimately how the adjudicators make decisions. And not that there aren't ways to train advisors or lawyers to better understand that, but in my experience, they have fallen short in that space, and that's been a real challenge for the parties. So I see this taking us in really challenging directions, and schools are going to have to think very carefully about who they empower to be in charge of the hearing and the cross-examination process. I also heard earlier this week in the NACUA presentation a suggestion that having the adjudicators asking questions in advance of the opportunity for cross-examination may help to combat the adversarial nature of the process by excluding questions that might have been asked on cross-examination as irrelevant because they've already been asked and answered. And so there's also something really to think about in terms of having really good preparation opportunities for the adjudicators or the board officers to know what they need to know, what is relevant, and try to ask as many of those questions in a way that they feel is comfortable and consistent with the goals of their process and the humane and just treatment of the parties involved in the process to minimize the need for cross-examination to get at the relevant information.
I'll just add here at the end before we move on to determinations. I mean, I think, and I know there are going to be small schools in particular who say, gosh, how do we don't have the resources, how are we ever going to do this? And in the past, in recent years, I should say, there have been those who have suggested pretty strongly that one way schools can go is to look towards sort of consortium relationships with other institutions and share resources, meaning adjudicators, among other things. And I know there's been some effort at that and some success, and I think you will see the emergence of professional adjudicators, folks who go around, but I also think there could be real opportunity for consortium, particularly of like schools, technical schools or career schools or public schools or community colleges, where the look and feel and function and operational sort of mechanisms are very similar among those groups, for example, to work together and come up with a consortium of available adjudicators that would be able to go potentially from one school to another under certain circumstances and help out. At any rate, the main idea there is there could be a shared resources opportunity for institutions to consider. So we've got about 10 minutes left, and I'm going to rely on the idea that if you folks have stuck in here with us for 2 hours and 50 minutes, if we go over 5 minutes, you'll hang around to go a little bit extra. I think we'll get done in close to the next 10 minutes, but we may run a couple of minutes over. I think I would rather, I don't want to race through the slides though, so hopefully you'll be patient with us. So determinations, again, we're still talking about things that are required components of your formal complaint process, right, for Title IX sexual harassment allegations. So you have to have a formal written determination, right? So in addition to your adjudicators being able to actually preside over the process and manage cantankerous advisors and relevancy questions, et cetera, they're going to have to produce a written determination at the end of it all. And that, if you've ever done this, and Leslie, I'm interested in your thoughts on this as well, but it's not an easy task, particularly for those who aren't used to writing things like this. And the department has articulated certain elements that have to be in that written determination. Of course, it's got to identify the allegations that are at issue. There needs to be a recitation of the procedural steps taken from the receipt of the formal complaint through the determination, including any notifications to the parties, interviews, site visits, methods used to gather evidence, and hearings held. I will tell you, this is something I always tell my clients should be in a written determination. And I actually think it's, to the extent, it's encouraging schools now as part of the formal rulemaking or under this rule to do it. It's not a bad idea. This is going to help you as institutions. It's going to ensure that these written determinations are better documents. You would want this in there anyway. Findings of fact supporting the determination need to be articulated. And conclusions. Boy, this is one of the hardest parts, right? Conclusions regarding the application of the school's sexual misconduct policy to the facts, including a statement of and rationale for the result as to each allegation, including a determination regarding responsibility, any disciplinary sanctions the school imposes on the respondent, and whether remedies designed to restore or preserve equal access to the school's education program or activities, that could be like sanctions, will be provided by the school to the complainant. And Scott, we've got this asterisk over here, and I know there are a couple of important concepts to hit on here.
Yeah, absolutely. And just to echo your point, I think this is really tough because this is a roadmap for appeals and potential plaintiffs' attorneys. So it's really important to get this right. But one concept that a lot of schools employ, and it might be a good idea for you might be considering, is breaking the responsibility portion and the sanctioning portion of the decisions into two separate processes. So the adjudicator would be responsible for determining responsibility, and the dean or someone else, another panel party, would be determining sanction. So we don't know the answer to this question. It wasn't clear in the regulations. We've been told it will be forthcoming in ed guidance on the blog that Aaron mentioned at the beginning. We hope the answer is yes, to give institutions that want to have this requirement or have it in the past the flexibility to do it. We also think dividing it into two processes would be helpful for relevance determinations, because only the pieces relevant to each specific aspect of your process would be germane to that hearing. I just wanted to point out that that's something that we don't know from the regulations, even with all 2,000 pages.
Right. They try to cover it all, but they don't always get there. Finally, that written determination also has to include your procedures and permissible bases for an appeal, and we're going to talk about appeals next. The only last note I want to make is the school must provide the determination to the parties simultaneously, which has been sort of a longstanding requirement that a lot of schools have already honored. And a note that per the rule, the determination becomes final either on the date when an appeal would no longer be considered timely, so when sort of that appeal opportunity has lapsed, or if an appeal is filed, on the school provides the parties with the written appeal determination. All right, so let's talk about appeals. Appeals are required, first of all. Again, hearings are required, and both parties have a right to an appeal. The school has to offer both parties an appeal from not only a determination regarding responsibility, but also the school's dismissal of a formal complaint or any allegations therein. So remember, way back when we talked about mandatory or optional dismissal, this idea that if the school determined that as pleaded, even if all the facts are true, you're not actually stating a Title IX sexual harassment matter, you have to give someone the opportunity to appeal that determination. So again, when we talk about, the timely resolution of these matters, there are so many opportunities for appeal, and, something could go to an informal resolution and come back. I mean, I think it is going to be challenging, among other things, just to execute on all these processes and get through things in a timely manner. Appeals may be granted on the following bases, and this is per the rule: a procedural irregularity that affected the outcome, new evidence that was not reasonably available at the time the determination or dismissal was made and could affect the outcome, the Title IX coordinator, investigator, or adjudicator had a conflict of interest or bias that affected the outcome. And these are pretty typical bases for appeals. One thing that's important to highlight, though, and sometimes is missed by folks who are non-attorneys or don't deal in appeals very often, is that, not liking the outcome is not a basis for an appeal, right? And if someone wants to file an appeal, they're going to have to articulate why one of these bases is implicated, right? A school also may offer an appeal equally to both parties on additional bases. So if you want to provide them more reasons to appeal, you can, as long as you provide it to both parties equally. The department does articulate specific procedures even for appeals. Schools generally must implement these appeal procedures, again, equally for both parties. In addition, they must notify the other party in writing when an appeal is filed. Ensure that the appeal officer is not the hearing adjudicator, investigator, or Title IX coordinator. So you got, they're trying to create all this independence and avoid conflicts of interest, which is good. On the other hand, it means you've got a lot of people that have to be trained and involved to get through all the stages of this process if you run the full process. Ensure that the appeal officer has received required training. Give both parties a reasonable, equal opportunity to submit a written statement in support of or challenging the outcome. Issue a written decision describing the result, and provide the written decision simultaneously to both parties. Okay, I mentioned earlier informal resolution, right? So what kind of opportunity is there? The good news is the department acknowledges informal resolution as an opportunity, and in a lot of circumstances, I'm sure the folks who are Title IX coordinators or administer these processes know that informal resolution can, in appropriate circumstances, be a good opportunity for the parties to get things closed more rapidly and in a way that everybody is satisfied. The department says a school may not, under any circumstances, require a student or employee to waive the right to an investigation and adjudication of a formal complaint, right? So if somebody files a formal complaint, you certainly can't force them into an informal resolution. Similarly, a school may not require the parties to participate in the informal resolution of a formal complaint or even offer an informal resolution process unless a formal complaint is filed. Now, this is an interesting wrinkle because you could have a situation where you have Title IX sexual harassment of which you have actual knowledge, so now you have an obligation to respond, and we talk about if you respond, you can provide supportive measures, et cetera, but this seems to suggest that an informal resolution may not be an option for resolving the situation short of a formal complaint being filed. The language here, I think, in the regulation is odd. I don't know, Scott, I don't mean to put you on the spot because this isn't something we prepared in advance, but do you recall in the preamble if there was any discussion on this point? Because I find this regulatory language sort of interesting in what it suggests.
And sorry, just to clarify, which specific point?
I'm just talking about this idea of whether or not, if you're short of a formal complaint, if someone hasn't actually filed a formal complaint, but you do have Title IX sexual harassment. This language seems to suggest that you can't offer an informal resolution process in that circumstance for sort of resolving the matter and putting it to bed.
And that's my understanding as well, but I can, yeah.
Okay. So we'll, to the folks on the lines, we'll figure it out. But I think that's an interesting wrinkle. And the regulatory language is odd. It seems counterintuitive to me that if you have qualifying Title IX sexual harassment and the parties are interested and the school is interested in pursuing some sort of informal resolution, in addition to supportive measures, that you wouldn't be able to do that unless someone first filed a formal complaint. So we'll look into that and see if we can put some guidance out or some thoughts about that. Okay, at any time prior to reaching a final determination, a school, so after a formal complaint has been filed, at any time prior to reaching a final determination, a school may facilitate an informal resolution that does not involve a full investigation and adjudication, provided that the school provides the parties a written notice disclosing the allegations, requirements for the informal resolution process, circumstances under which it precludes the parties from resuming a formal complaint, if any, and any other consequences of participating in the informal resolution process, as well as the records that will be maintained or could be shared, and obtains the parties' voluntary written consent to the informal resolution. I know in working with my clients, one of the challenges that occasionally arises is when someone departs or it's hard to get in touch with them or if they've departed the institution, sort of whether you can apply some sort of informal resolution in that context. And I know there are a lot of wrinkles that are going to be out there that schools are going to have to think through. Informal resolutions not available to resolve allegations that an employee sexually harassed a student. And at any time prior to agreeing to a resolution, any party has the right to withdraw from the informal resolution and to resume the formal complaint process. So I understand that to mean, just to be clear, all the parties could agree to enter into an informal resolution process, but as long as you are short of an actual agreement being achieved, they can always go back to the formal complaint process, which I think is consistent with the way a lot of policies at a lot of schools already work. Scott.
And I think the only thing that I wanted to add is schools are not required to establish an informal resolution process. So to the extent that you don't think that's in your school's best interest, then you could just decline to provide a process, and this doesn't apply to you. But to the extent that you do, then you have to follow the rules.
All right. So we got 2 more sections left, guys. Record keeping and retaliation. I'm going to skip on the last section. It's just about some conforming changes, technical changes that were made that you can read about. But we do want to get through these 2, and they're pretty tight. So stick with us. I think we'll be done in about 5, and then we can go to questions. Record keeping. This is important. For each sexual harassment complaint, so I'm talking about a Title IX sexual harassment complaint, the school must maintain records for 7 years. And those records have to include records of any actions, including supportive measures, taken in response to a report or formal complaint of sexual harassment, the basis for the school's conclusion that its response was not deliberately indifferent, documentation that the school took measures designed to restore or preserve equal access, right? And if the school did not provide supportive measures, and Scott spoke to this earlier, the reasons why such a response was not clearly unreasonable in light of the known circumstances. So from the get-go, whenever you receive, even have actual knowledge of Title IX sexual harassment, much less a formal complaint, you're going to want to have a process for how you maintain records, where those records go, how they're kept confidentially, and how they're maintained over that period of 7 years, right? You're going to want to have all that figured out in advance. And I think even when you have Title IX sexual harassment that it falls short of a formal complaint, for example, and you may address just through supportive measures, you're going to want to have a process whereby you sort of create a memo to file and document what was done in each instance so that you can satisfy all of these requirements. If there was an adjudication, so if you did get to a formal complaint and there's an adjudication, your records also have to contain any determination regarding responsibility, so that should be in the written determination document. Any audio or audio-visual recording or transcript, and recall you are required to keep one or create one of the hearing. Any disciplinary sanctions imposed on the respondent, any remedies provided to the complainant, any appeal and the result, and any informal resolution if one occurred and the result. Apart from any specific proceeding, institutions also must keep for 7 years all materials used to train title coordinators, investigators, and adjudicators, and any person who facilitates an informal resolution process. And this last bullet's another one that caught the community off guard, I think. Further, schools must make these training materials publicly available on their websites. So just to be clear, all those modules, anything along those lines that you are providing to your Title IX personnel and that they are reviewing, the law indicates they have to be publicly available. So the only blog post, remember I mentioned that on the OCR's blog post, they've already have one blog that they put out. This is what it's about. And they actually say, if you've got a provider who has created training for you, and it is, that provider, it's proprietary training and they own it, and you don't have intellectual property rights to it, you've either got to get them or you can't use that training, which I think is sort of astounding. And I don't know. I think there's going to be pushback. There may be some further discussion on this. Frankly, we don't create proprietary training, but we've talked internally, and I can't help but wonder what the folks who create proprietary training products are going to do and how they're going to continue to sort of manage their business model even, right? Because this strongly indicates, and the blog backs this up, that, if you've got a training video, that's supposed to be publicly available on your website where everybody can view it, right? And at least the way the discussion around intellectual property reads in the blog suggests that you can't just have a listing that says, yes, we use this video. I mean, it looks to me like it is actually supposed to be available, the whole video on your website. So in some cases that won't be an issue, but in others it may be. Finally, retaliation. I'm sure all of your policies prohibit retaliation. The department in Section 106.71 specifically also prohibits retaliation. And there's more to this. We didn't include, all the regulatory language, but it's what you would expect, right? It says no school or other person can intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege secured by Title IX under this part, et cetera, et cetera. Addressing certain anticipated nuances, the department also, under the retaliation provision, notes that the exercise of rights protected under the First Amendment does not constitute retaliation. And I think what that's getting at is if someone is exercising their free speech rights, right, in the regulation, it suggests that does not constitute retaliation. That could be a sticky wicket, depending on the nature of the speech that they are exercising. It is not retaliation if a school charges an individual with a code of conduct violation for making a materially false statement in bad faith during a Title IX proceeding. So that's another interesting carve-out that they took care to note. And then finally, I know, Scott, we wanted to talk for a few minutes, and this is important, about the relationship between Title VII and Title IX, because the department has said, this process, to be very clear, applies not only to employees, but even complaints by one employee against another.
Absolutely, and I feel like we're lobbing a grenade here at the end of the presentation, but this is really important.
It's not the first. So it's not the first.
but let's save it to the end. So we talked about Title IX. Hopefully everyone understands Title IX. For those that aren't clear on Title VII prohibits sex discrimination in the employment context. And as you can see from the quote, the department is aware there are different standards under Title IX, but the department's clear position is that there's no inherent conflict between the two laws, and schools should comply with both. That may or may not be true, but it is clear that the different standards will make adhering to both laws not easy to nightmarish for your HR departments. So we wanted to highlight a few key differences between Title IX and Title VII, with the understanding that you should go back and kind of really dig into this as you're developing your process. So under Title VII, the conduct at issue must be severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Under Title IX, the standard here is severe and pervasive. So when you think about a Venn diagram of the two, conduct could be severe and potentially violate Title IX, but not pervasive. It could be severe and actionable under Title VII, but not severe and pervasive and actionable under Title IX. So Title VII is broader than Title IX, and people administering your employment policies need to be aware of that. With regard to the knowledge standard, under Title VII, the employer will be liable for harassment by non-supervisor employees or non-employees over whom it has control, if it knew or should have known about the harassment. Under Title IX, or with the actual knowledge standard we discussed earlier, no constructive knowledge. Under Title VII, an employee should take corrective action if they knew. Title IX, we're talking about the formal complaint and actual knowledge. And last, Title VII does have extraterritorial application for U.S. citizens working abroad, where Title IX is clear that has to be within the bounds of the United States. So responding to the many comments received on this issue, the department took a rather snarky, flat-out note that if you can't comply with both, then you don't need to receive financial aid, and you may want to forego assistance if you don't want to speak to that.
So that's an easy resolution. Just leave Title IV. That's your option.
Right. So the department's clearly expecting compliance, and there are going to be some rough patches in the road to adhering to both.
So we, like I said, we're gonna jump through this last section. I did want to take just a second though to talk about, practically speaking, next steps. We know that this has been a tremendous amount to take in, and by the way, I mean, to the extent folks are looking for assistance, we obviously do this kind of work and would be very happy to work with you on understanding this rule and trying to get across the finish line here. But setting that point aside, Scott, maybe you and Leslie could talk about a little bit your thoughts on practical implementation And schools that are sort of sitting down after this, all jokes about wine aside, and really tasked with, next steps, what would you suggest they do over the next week and 2 weeks and 2 months?
I'll let you take the first crack at this, but I just found the provision about the informal resolution, so I wanted to let you know. So the preamble clarifies that the intent of 106.45b9 is to state that recipients may not offer informal resolution unless a formal complaint has been filed. So I know I read that,
yeah.
I found it. But Leslie, I'll let you jump in on the actual substantive question first.
Yeah, I mean, time is of the essence, so I'm going to try to just give you a couple of big picture thoughts. Obviously the August 14th implementation date is going to sneak up on us pretty quickly. And so it's important to start to think about what your next steps are and who needs to be included in those steps. You need to get buy-in early on from sort of all levels or constituents within your institution that need to be part of this decision, whether they be the general counsel's office, compliance officers, a provost, human resources, student affairs, campus safety, student conduct, really thinking about, who in your community needs to be involved and begin that process as soon as possible. And this is a really difficult time to be prioritizing this big of a shift in process, but if the August 14th deadline holds, you've got to be compliant by then. And so I would say find a way, create a task force, put a single leader who likely will also be a main contributor to the drafting as in charge of that task force. That'll give somebody accountability for keeping this moving and set a very clear project plan to get a draft of your new process and rules in place for in ample time to communicate that to your community members. I would also tell you to think about who your advocates for implementation are across practice, remembering that peers like to hear from peers. So thinking about employee resource groups or student advocacy groups that could help you not only formulate the process or the policy going forward, but help you disseminate that process and policy to be in compliance. But the bottom line is, if what you've heard today seems daunting, that's not unreasonable. If it seems different subtly or drastically from what you're already doing today, that doesn't surprise me either. But time will be of the essence, and despite competing priorities for your time and competing concerns across sort of the globe for academic institutions right now, you've got to make this a priority and get your buy-in from most senior leaders needed in the institutions to get moving as quickly as possible.
Yeah, I 100% agree with everything you just, great advice you just said there. My only thoughts would be, when you do develop your group, have all your documents ready. So figure out the mandatory requirements of the law and have that set and how you're going to accomplish that. Figure out, we talked a lot about flexibility that's established in the law, like standards of evidence, whether to have informal resolution, one adjudicator versus board. So things that you have flexibility on, make sure you can tee those questions up in order to be able to efficiently move through the process. Try and figure out what other impediments there may be. So is there a state law on transcript notations or standards of evidence? Is there a CBA with your with unions that dictate sexual harassment? Do your faculty handbooks treat sexual harassment differently? Do your professional schools differ from your undergrad? So have all the documents collected in one universe and then hopefully assess where you're at. And then my personal preference and the way to do things is figure out the general direction, give someone a deadline, get them a draft, tell them whatever time it's due, and then have the group edit it and figure out who's editing and who's providing just clarifying input. But it's always easier to edit a draft than to kind of give different people different provisions to write. And there's a lot of new things to draft, in addition to policies and how many policies you want to have and processes, but there are written notices that you want to have figured out and vetted, and materials and trainings and all that stuff. So putting someone in charge and developing a list, obviously, is a good advice too.
Yeah, and I think, I'll just add in one last sort of plug, Aaron, before you jump in and finish up, is that, I think it's also really important to know what you know and know what you don't know, and know where you have expertise and where you might need it. My vantage point as a senior leader within a very large, complex university with deep resources is very different than the perspective of some of you who are listening in or will be listening to this later, working at much smaller institutions with less resources. And to the extent that you need outside counsel to help you navigate through this, identify that, and even during trying times, try to find the budget for that as quickly as possible, because knowing what you don't understand is just as important as knowing what you do understand.
Yeah, great advice. So the last section here, updates to rights and responsibilities. This was a revision actually to an earlier section, 106.6, and just talks about some of the conforming edits. I do suggest, I'm not going to go through this, but I do suggest you just take a quick look at these slides. Again, you've got the slides, the presentation's available. Always invite folks. Remember, this webinar, like all our higher ed webinars, is available free and on demand. So on our TCLE library page, the same page where you registered, I would expect by tomorrow this entire presentation will be on demand. So if you want to pass it along, if you want to watch it again, you're welcome to do that. Also, we've got some other content here that you may find interesting, specific to higher ed, I should say. Our blog, Education, we are writing a lot about the CARES Act these days, and now Title IX as well, but please feel free to check that out at your leisure. We also occasionally make things available. We've got a new bar defense rule reporting guide coming out soon. We're going to do a joint webinar with DEAC, the accreditor, about some of the upcoming state authorization requirements and the disclosure requirements for professional licensing programs. Look for that soon. And before we get into Q&A, and we will here, I just wanted to say a thank you, a special thank you to Leslie, you, and Scott. I deeply appreciate all the time you guys put in a very short time frame, and for you, Leslie, outside of your job description, to participate in what has really been a marathon of a webinar. And I am deeply grateful, and I hope that folks who have listened in feel like you've gotten a lot out of it. I have gotten a lot out of it personally, both in the preparation and just being part of this. So that having been said, we promised some Q&A, and we're going to do our best here to get through some of the questions. I was going to make a joke that there aren't any, but I'm too tired to even make the joke. There are several hundred, so I don't think we'll get to all of them, but I will jump back and we'll try to get through some of them anyway. So let's see, and I'll just throw these out, Scott, to you and Leslie, and let you take them as you will. What does your picture of cross-examination by an advisor look like under the new regulations? We've talked a lot about that, but sort of in your mind when you conceive what this looks like, what do you think?
Well, I think it depends on the advisor. I think if you have a respondent or complainant that's hired an attorney, the regulations make clear that that person is not acting in the capacity of an attorney for that process, but the expectation of the party is that they will be zealously advocated for. So I think if you have an attorney that views it as an adversarial process and is interested in zealously defending their client, I think it could look a lot like a potential courtroom, and really it would be up to the presiding officer to maintain decorum, where you could have a very skilled litigator take advantage of a process. On the other hand, you have the attorney, the responsibility of institutions to provide advisors in certain situations, and that seems like it depends on what pool of advisor the school is able to get. I think I mentioned earlier, while the advisor is always required to conduct the cross-examination, the regulations don't require equal competency. You don't require an attorney. At base, you just require someone to relay questions from the party. But in that sense, you also want someone that understands the process and can competently handle it. So I think it could run the gamut from law and order to a kind of civil math professor relaying questions, and it really just depends on the nature of the proceeding and how high tensions are.
I think that's math professor discrimination, by the way. Go ahead. Sorry.
and I don't have a lot to add to that, because I think that, Scott, you described it exactly right. We don't know yet what that's going to look like, and it will be determined by who's serving in the advisor role. But I do think that schools have an opportunity to set rules for decorum and to think about how to minimize the need for cross-examination by building into their process a role for the adjudicator or the hearing board to get as much information covered before you move to cross-examination as possible, to try to eliminate the disparity in competency, at least on the sort of technique of cross-examination plane, and to try to limit the adversarial nature. But I think we're going into a little bit of a Wild West on this until we get some experience and some learnings.
That's a great point. And just one really quick question. While it dawns on me, while institutions are thinking of potential advisors, the tendency may be to mine a law school or persons with legal degrees if you have that available at your campus. But this is a totally separate kind of process from anything that a lawyer would deal with. And so I don't think a lawyer may have some advantages, but they also may be tripped up in assuming federal rules apply and all that stuff. So a lawyer is not necessarily the best potential person. Depends on your situation.
That's right.
Very true. All right, I have a question for Scott, you, and then one, Leslie, for you. I'll start with Scott. Is the Title IX coordinator, if the Title IX coordinator signs a formal complaint, is the institution a party to the complaint along with the complainant?
No. So if a complainant files a formal complaint, then the Title IX coordinator would not be involved in signing anything. So the complainant can go forward with their complaint. It'd just be the complainant and the respondent, and the school would stay neutral. The only way the Title IX coordinator would sign a formal complaint is if there is no complainant, but the Title IX coordinator has made a decision that to have a non-deliberately indifferent response, it needs to go forward with the grievance process. And in that case, the regulations make clear that the Title IX coordinator is not a party. They're still acting impartially, and they're just there to ensure the non-deliberately indifferent response is taken forward. And that presents a ton of challenges with how to prosecute, what evidence will be available at the case, and that's a whole kind of separate can of worms if you need to dismiss it on a discretionary basis because there's not sufficient evidence. But in terms of the Title IX coordinator, they would never become a party that's adversarial to another party.
Yeah, but you could have a situation, for example, where you have an organization on campus and you've received complaints over a period of 2 or 3 years from a wide range of individuals who may not even be at your institution anymore, but that pattern of conduct has led your Title IX coordinator to say, we've got a problem and we need to address it or we're going to be deliberately indifferent. I don't want to, that could be an organization or a unit or whatever, but you could have a situation like that, right, where a Title IX coordinator is has identified a pattern. You don't have a particular complainant, but there's a sense that action is required.
Right. And just to please.
Yeah, go ahead.
Just put a button on it. The rules make clear that you couldn't kind of take a whole fraternity and put them through the process. It would have to be like a serial predator you'd have to kind of identify a person or people. So it's not like an organization. So that's all I'm going to say.
Right. Right. By the way, I'll just say, apart from this, formal complaint of Title IX sexual harassment, I mean, if you've identified discrimination based on sex on your campus, I mean, you can still take steps to remediate that. It doesn't even have to be sexual harassment, right? It could be some other concept or form of discrimination based on sex, right? So again, these are all about setting floors, not ceilings, and it's not about, in most cases, you aren't prevented from doing things if you want to try to make your campus a better place. Let's see. So this one's for you, Leslie. You're talking about consent, and the question is, do you have a suggested definition of consent?
Oh, I was wondering if somebody was going to ask me that question. I served as an adjudicator only on behalf of one university. And so, my mindset around what consent means is very much grounded in that university's policy, which is, that consent has to be voluntary, knowing, and now I know that there are folks, former colleagues of mine who are on this call that are going to tell me I botched it, present and ongoing. And I happen to think that makes a lot of sense, and that's why I raised earlier when I was talking about consent some of the questions I think you need to think about. How do you communicate consent? What does it mean for consent to be present or active? What does it mean for the parties to know that consent is present or active? What does it mean to be ongoing? Does consent to one sexual act, can it or does it imply consent to a different sexual act? Sometimes the answer, I think, to that is yes, and sometimes the answer to that is no. And really trying to flush out as much as possible how the rules for consent are going to be applied to sets of facts that you have seen. And I think that if you work for an organization or an institution that has been managing Title IX cases for a while or sexual misconduct cases for a while, there should be a nice breadth and depth to examples you can pull from to try to help define consent and implement that definition or train your adjudicators and advisors on that. And if you don't, this idea that Aaron brought up earlier around developing a consortium, finding some guidance, some peer set guidance and support for each other, or looking, if you can afford to outside counsel for that, will be really important. But I'm less sort of wedded to there being specific components to consent and more committed to there being clear communication and understanding of how those components apply to different sets of facts and what an adjudicator or an advisor would have to grapple with in making those evaluations.
So Scott, this question is on responsible employees, and the questioner says, in the past we were trained that responsible employees had to report to the title, if they became aware or they received a report of sexual misconduct, they had to report that to their Title IX coordinator, even without the consent of the student. Has this changed?
So on responsible employees, so that concept is kind of not applicable anymore. What the department says is you have wide discretion to implement your own policy for that. So a school could implement a policy that says, and a lot of schools do, if someone comes to you, you must report to the Title IX coordinator regardless of the wishes of the student, and that could be kind of how the institution wants to go forward. But since you have discretion, what the point the department was making in the preamble was you could kind of have a different set of expectations. And so if that approach worked for you, keep it. But if you'd rather have a policy that says only some groups of employees have to report, or it's discretionary, or you can take the consent of the student into account, that's totally permissible. The key issue